information manager. Item number 12 and item number 12, 17. We are not here to adjourn the matter. So, make a mention tomorrow. Make a mention tomorrow.
Supplementary daily. Item number 8.
Supplementary daily item number 8. Just a minute. Yes, Rob. Presenting.
The report has been placed.
Yes, report has. And कैमरा ऑन करंतु.
IIC बनाई. Unmute करंतु.
So he is there. He is alive. এটা কার সাথে এখন অন করছেন বলছেন যোগটা না
অন করুন.
যোগটা নাই এখন
IIC. আসলে unmute करो. Yes, IIC Bonai Police Station, Raurkela.
सर नमस्कार सर.
What is your name?
सब ज्ञानेंद्र कुमार साहू.
We are calling for the well-being report of the appellant since long. Why are you not submitting it earlier?
Sir, I have received the intimation yesterday by getting a call from Honorable Assistant Standing Counsel, sir.
Prior to that, you have not received any communication?
Sir. Yes, sir.
Quiz chair since when you are there?
Sir, since 2 years I am there here.
Yes, so the Land and Advocate General Office is having the documents to show that they have even sent you this information in the month of April 2025 and again 27. Whenever any communication is made, act swiftly and reply to the Land and Advocate General Office.
Sir, followed, sir.
Mr. Gyanendra Kumar.
Active representative.
Yes.
Active मध्ये असतात.
Gyanendra Kumar Sahu.
Sahu.
Gyanendra Kumar Sahu, Inspector in charge of Bonai Police Station, Raurkela, is present, and he has submitted a well-being oblique status report of the appellant Devraj Munda, wherein it is indicated that the appellant is alive and he is residing with his family members in his village. The report is taken on record. Where is that appellant? कहीं से?
Active देखा.
Sir.
अपन उठी जान संग हाँ. और तुम ना कौन?
नौकर आगे.
हाँ?
देवराज मुंडा सर.
देवराज मुंडा.
आगे.
तमरो 2007 ମସିହାରେ
ଆଜ୍ଞା
ତ 2 ଦଫାରେ ତମକୁ ଆଜୀବନ କାରାଦଣ୍ଡ ହେଇଛି
ଆଜ୍ଞା
ଆଉ ତମେ ବେଲରେ ଅଛ।
ଆଜ୍ଞା
ବର୍ତ୍ତମାନ କେସ୍ ଶୁଣାଣି ପାଇଁ ଆସିଗଲାଣି,
ଆଜ୍ଞା
ତେଣୁ ଓକିଲ ମାନେ କେହି ନାହାନ୍ତି। ତମେ ଓକିଲ ବାବୁଙ୍କୁ ଦବ ନା କଣ କରିବ?
ନମସ୍କାର ଆଜ୍ଞା।
ହୁଁ ଓକିଲ ଦବାକୁ ଚାହୁଁଛ କି? ନା ଏଇ ଆମର ହାଇକୋର୍ଟରେ ଯୋଉ ଅଛି ଲିଗାଲ ଏଡ୍, ଯୋଉଠିକି ମାଗଣାରେ ଆଡଭୋକେଟ୍ସ ଆଇନ ସେବା ଯୋଗେଇ ଦିଆହବ, ତା ଭିତରୁ ଆମେ ଇଏ କରିବୁ।
ସେଟା ବି କରୁନ୍ ସାର୍, ମାନେ ମୁଁ ତ ବିଜୟଲକ୍ଷ୍ମୀ ତ୍ରିପାଠୀ ଓକିଲ ହାଇକୋର୍ଟର ଥିଲା ସାର୍।
BL ତ୍ରିପାଠୀ,
ହଁ ବିଜୟଲକ୍ଷ୍ମୀ ତ୍ରିପାଠୀ।
ବିଜୟଲକ୍ଷ୍ମୀ ତ୍ରିପାଠୀ।
ବିଜୟଲକ୍ଷ୍ମୀ ତ୍ରିପାଠୀ ବର୍ତ୍ତମାନ ସରକାରୀ ଓକିଲ ହେଇଗଲେଣି,
ଆଜ୍ଞା
ତେଣୁ ସିଏ ଆଉ ତମ ପାଇଁ କରିପାରିବେ ନାହିଁ, ବୁଝିପାରିଲେ?
ଆଜ୍ଞା
ତେଣୁ ବର୍ତ୍ତମାନ କାହାକୁ ଦବାକୁ ଚାହୁଁଛନ୍ତି?
ଦେଖୁନ ସରକାରୀ ଥର ଦେବନ ସାର୍ ଆଉ।
ଆଉ ଜଣେ ଓକିଲଙ୍କୁ ଦେଲେ ଆପଣଙ୍କର କିଛି ଆପତ୍ତି ନାହିଁ ତ? ଆପଣ ତ ନିଜେ ଦେବେନି, ତେଣୁ ଆମର ଯୋଉ ଲିଷ୍ଟ ଅଛି ହାଇକୋର୍ଟର ଯୋଉ ଲିଗାଲ ଏଡ୍ ପ୍ୟାନେଲ ଲିଷ୍ଟ, ତା ଦେହରୁ ଆମେ କୌଣସି ଆଡଭୋକେଟ କୁ ଦେଲେ ଆପଣଙ୍କର କିଛି ଆପତ୍ତି ଅଛି କି ନା ନିଜେ ଦେବେ? କୁହ।
ନାଇଁ ସାର୍ ନାଇଁ
ନିଜେ
କରବାର।
ଦେବେ?
ଆଜ୍ଞା
ଆପଣ ନିଜ ଖର୍ଚ୍ଚରେ ଓକିଲ ଦେବେ କି? ନିଜ ଖର୍ଚ୍ଚରେ ଓକିଲ ଦେବେ କି?
ନାଇଁ ସାର୍ ଆପଣ କ୍ଲିୟର ଦଉନ୍।
ସରକାରଙ୍କ ତରଫରୁ ସାହାଯ୍ୟ ପ୍ରାପ୍ତ ଓକିଲଙ୍କୁ ଆମେ ଦେବୁ।
ଆଜ୍ଞା
ଆଚ୍ଛା,
To give the list, but it has to be. This no, you cannot ask her sister to argue the matter.
no, no. ଏଇଟା ତ ଆମେ ଲିଷ୍ଟ ଅନୁସାରେ କହୁଛୁ। କତ କଣ ନମ୍ବରକୁ ଦେଇଥିଲୁ ସେ ବିଷୟରେ ଗଲା। ନେକ୍ସଟ କିଏ ଅଛି? ଏଇଟା ହବ।
Follow କରିକିନା ତା ଦେହରେ ସିନିୟର ଆଡଭୋକେଟ ମାନଙ୍କ
ଇଏ କେହି ଆସିବେନି, ପୂର୍ଣ୍ଣ ଆସିବନି, ଲକ୍ଷ୍ମେଶ୍ୱର ତଳ କୋର୍ଟ ପ୍ରାକ୍ଟିସ।
ବାହାର ଯାଇଥିଲା, ଇଏ ଡିଷ୍ଟ୍ରିକ୍ଟ ଆମର ସିଭିଲ ବାହାର ଯାଇଥିଲା, ସବୁକୁ ଆଡଭୋକେଟ ଅଛି।
ଏ ଭିତରୁ କେହି ଆମେ କରିବୁ। ଇଏ ଅଛନ୍ତି କିନ୍ତୁ ଇଏ ଆସିଥିଲେ ଅଛନ୍ତି।
Mrs. Prabhasi Naik is engaged as the counsel person from these funds of panel. Copy of the paper book shall be handed over to Learning Council and matter to be taken up for hearing and hearing for December 2025. The registry shall intimate council about प्रभासी नायक को जणई देबे हैला जे तांकर एंगेजमेंट हिची एवं जेसी पेपर बुक का कलेक्ट करबे की करे the name of BL Tripathi and her associate shall not be reflected on the register. ये हमें अपन को केस रे प्रभासी नायक फिल्म को माने एंगेज कलु तांकर सी जदी केस पढ़िला परे फाइल पत्र पढ़िला परे जदी चाहती जे आपनको संगे केस विषय किसी आलोचना करिवे ताले से सुविधा जोगी दिया जीवो तांको एवं आपण तांको तांको संगे केस विषय जहाँ कहवा कथा आपण कहबे हला। हां हां ठीक है,
तांको फोन नंबर इत्यादि जोगे दिया जिवो,
फोन नंबर जोगे दिया जीवो,
आईएसी के माध्यम रे जणे दिया जिवो।
ଆଜ୍ଞା
ताकि आईएसी को तांकर फोन नंबर दे दोंतो एडवोकेट करो तापरे तांकर फोन जदि किसी कांटेक्ट नंबर अछि आनिकिनी प्रभासी मैडम के दे दियंता ताले से पढ़ी साइला पर जदि किसी दरकार हला ताले तांग संगे वर्चुअल मोड रे इंटरेक्शन को
Mr. Sahu, IIC.
Sir, namaskar sir.
Your police jurisdiction is under Raurkela Police District or Sundargarh Police District?
Sir, Raurkela Police District sir.
Raurkela Police District.
Sir.
All right.
ଆମେ ତାଙ୍କୁ ଜଣେଇ ଦେଇଛୁ ଯେ ନୂଆ ଓକିଲ ବାବୁ କିଏ ନିଯୁକ୍ତି ହେଲେ ତାଙ୍କ ନାଁ ବି କହିଦେଲୁ
Sir,
ଏବଂ
sir,
ଓକିଲ ବାବୁଙ୍କର ସେ ତାଙ୍କୁ କେସ୍ ର ଫାଇଲ ପତ୍ର ସବୁ ଦିଆହେଇଯିବ।
sir,
ସେ ପଢିଲା ପରେ ଯଦି ଆବଶ୍ୟକ ହବ
sir,
ତାହେଲେ ତାଙ୍କ ସାଙ୍ଗରେ ଭର୍ଚୁଆଲ ମୋଡ ରେ କଥାବାର୍ତ୍ତା ହବା ପାଇଁ କେସ୍ ବିଷୟରେ
sir,
ତାହେଲେ ଆପଣଙ୍କ ଜରିଆରେ ସେଟା ଆରେଞ୍ଜମେଣ୍ଟ କରାଯିବ ଏବଂ ଯାହା ପଚାରିବେ ସେ ତାଙ୍କୁ କହିବେ ଆଉ କଣ। ତାପରେ
sir,
ଶୁଣାଣି 8 ତାରିଖ 9 ତାରିଖରେ ରହିଛି ହେଲା, ଏ ବିଷୟରେ
sir,
ସବୁ କହିଦିଅନ୍ତୁ
sir,
ହେଲା।
sir,
9
sir,
ଡିସେମ୍ବର।
sir, sir,
Yes, next.
sir, namaskar. Sir.
Personal appearance is different.
Item 1.
Total Falcon. He certainly belongs to Baleshwar and Ongo. Now he is residing the information from Talcher. I pray from Saturday so that we can call for a report from Talcher building. IIT Talcher.
କଣ ହେଇଛି?
ये ଫାର୍ଷ୍ଟ ହେଲା ବାଲେଶ୍ୱର ଆଡ୍ରେସ ଥିଲା ଯୋଉଠି ଚିଠି ଯାଇଥିଲା ଏବଂ ଅନୁଗୁଳ ଯାଇଥିଲା।
ସେ ଏବେ ଅନୁଗୁଳରେ ଅଛି।
ସେ ଏବେ ତାଳଚେର ରହୁଛି। ତାଳଚେର
ମାନେ ବେଲ ହେଇନି କି ତାର?
My lord,
ଜେଲରେ ଅଛି ତ?
my
His
lord,
appellant is in contact with you.
He has been granted bail on
The appellant is in contact with you.
in behalf of Mr. Devashish Panda,
Yes.
appellant may be recorded.
Appellant is alive.
Appellant is alive.
କଣ appellant?
Alive.
ଆପଣଙ୍କର ମୁଣ୍ଡ କୁଣ୍ଡିବାକୁ ସମୟ ହେଲାନି କି? ଆଁ?
Sorry, sir.
Report has been alive.
Comb your head. Yeah.
Sir, my lord.
To argue the matter. Yes, what is the prosecution case?
Lordship, Mr. Panda is argued.
A regular appeal. It's not necessary that Mr. Panda would argue. He can argue. There is no. It's not a jail criminal appeal that will wait for the engaged counsel.
My lord, I am not ready, my lord.
Let the report come. Let the report
My lord,
come.
my lord, let it come some other date, my lord.
We are not sitting here to grant adjournment, and that too in item number 1.
Mr. Panda is not well. Good. After paper.
My lord, we obtain to paper books, my lord.
Mr.
Begging your lordship's pardon.
Yes, what is the case?
My lords, this is a case of uxoricide, my lords. Actually, we have no intimation from the client and we don't have paper books. Can we keep it to some other day so that I can verify?
Panda, this is item number 1. And
Yes, my lords. My learned friend who was mentioning, my lords, is raw. I had told him to mention that we are not in contact with the client. We'll find out whether the client is alive.
No,
report
that
has
is-
come.
Report has come.
That he is alive.
Yes.
Yes. Well, then your lordship may call it some other day. We'll get the paper books.
But ask somebody to collect it today itself.
Yes, I'll do it.
Mr. Devasis Panda, Land Council, appearing through virtual mode, submits that you will collect the paperwork in course of the day, and the matter may be taken off. Can it be taken off this week or next week? You want?
Your lordship may call it next week.
2nd December,
Yes, madam.
and the matter may be taken up next week. Put up this matter on 2nd December 2025. Have you collected paper book? This matter on 2nd December 2025. Yes, next.
Item 2.
Item 2, as for information, the persons residing within Mangalore. Today I have contacted with him. They intimated that he will visit.
Reporter लिखी दिला था item number ये SP पर reporter लिखी. The superintendent of police has given the report that the appellant is alive. That is at flag E. Superintendent of police on this. Yes, item number 2.
That as per the report last occasion I have produced that they are residing in under Mangalore jurisdiction. We have sent a letter. I intimated he visited and did not find. That's why I found. That's why I intimated that 1 week time is allowed for further information about it.
ये भी बेलू गलानी सब 2007 मसीह तापरे appellant number 1 ଯାଇଛି 2007 appellant
26
2 has been released on bail on 26 2008 and किसी कटक के सामने डेलू 18/11/2025 रे
18/11 I have also intimated the Lalbagh. They got
कोन घरु जणा पड़नी बंची जंदी नाही दीटा
से found the song because verified that at least 1 week.
मंगलवार थोरिया शहर दी जणो को घर आज टापियो परमानेंट रेसिडेंट
ଯାଇଥିଲେ ଯେ ସେ ପାଇଲେନି ଦି ଜଣ କିନ୍ତୁ ଚାହିଁଲେ ଗୋଟେ
ଆମର ସେ ପାଆନ୍ତୁ କି ନ ପାଆନ୍ତୁ ଆମର ଦରକାର ବଞ୍ଚିଛନ୍ତି କି ନାହିଁ.
That's why intimated only to other live alive or dead if that intimation is required. Today I have
ଯାଇଥିବେ ଆମେ କଣ ତାଙ୍କୁ କହୁଛୁ appear କରିବାକୁ. We just want the intimation because they were young when the
taken out Friday so that I can collect.
You know, Friday no Thursday near.
Sorry.
Hear this instruction. Okay. Because the clients are not in contact with the appellant. Like the previous case also, that happens once they go on bail and in the meantime 20 years almost passed. So they might be thinking that the case is over.
First day.
Day after tomorrow it will come. The Land and Council for the state submitted that the matter may be taken up day after tomorrow in order to ascertain the well-being of both the appellants. Put up this matter on 27/11/2025.
Item 3.
Single appellant?
Sorry, little late, man.
No, four appellants.
I'm sorry, little late.
Mr. Mishra, these appellants are in contact with you?
No, nothing. This order was on 2010. So after 15 years, it is listed.
No. We just wanted, that is why we asked that whether they are.
No, Only one person is in contact, 3 persons are not in contact.
No, we just want to whether they are alive or not. That was
Your lordship may direct the police to get the information.
appellant's answer.
Because I am not in touch with.
No, but you are to argue the matter. What can be done? It's a old
Let it
matter.
come after 4 weeks so that I can
No.
contact.
You see, this bench has been constituted.
Your lordship may
That purpose.
then engage some amicus.
No, how it's a regular case, sir.
I know, but I'm not regularly in touch with.
No. The problem is the jail criminal appeal is allowed.
Then the other thing is, your lordship knows how the law appears. It's
No,
not
if you want, we can make arrangement so that you can have contact with them, virtual mode.
The one person said, "No, virtual mode they are all laborers. Their whereabouts is not known now. They might have been alive, but the one person with whom I contacted yesterday, he said that all are in Madras.
No, your one is in two are in Madras. That is Lochan Rona and Bhopal Rona.
I don't know,
but
yesterday
they are in, but other two are residing in.
I talked to Lochan Rona. He told me
Lochan Rona is in Chennai. That is the report also. And he is working in a company doing labor works. Similarly, the Gopal Rana is also working in Chennai in a company. But the other two, that means Jai Krishna Rana and Bhujawala Rana, they are in village and they are living with their family. And
I contacted only one person, Lochan Rana, over phone. He said that probably along with him, the 3 persons are in Chennai.
No, Mr. Mishra, the thing is that it is a 2004 criminal appeal and the appellants are alive. You collect the paper book, whatever you want to you, and if you want that, we can also arrange. If you want to have talk regarding the case matter also, virtually we can make necessary arrangements so that the IIC will do the needful.
No.
But if you do not want that,
the man needful can never be complied with any other than the client.
the
Instruction that nobody can give. If the IIC will give the instruction also, then it will be better.
No.
We'll ensure their presence in the police station so that they will have in.
I'm not interested with that. I'm interested with the material instruction. We are lawyers. We don't get salary.
that is up to you. You have to
And you see, the
Yeah.
matter is we are sitting for that matter and the dedicated bench is there.
Last data
No, we are not
that is-
concerned
we
with
are
that.
not. We
We
are
are not
just-
concerned.
After
That is
15
there.
years, it is listed.
Now
When I
that
know
it has come,
in my record, the last listed on 2010.
Yes, you are right. 3/3/2010 is the last order. But what we want that you collect the paper book, and since this is a special bench constituted, we cannot adjourn it for as long as you want that 1 month.
Then it is only the remedy is that to your lordship effort from amicus curiae, because without instruction I can't argue. I'm not freely available. Your lordship knows that.
No, we are not counseling you, Mr. Misra.
I know that. I am also expressing that.
The thing is that,
No, I never said that you're also compelled, but I am also to say how a lawyer appears.
no, that is that. You are
On
right.
instruction, if no instruction, no appearance.
So, if you say we can engage somebody else,
That is it.
amicus curiae.
But the one client to whom I could contact, he said that please give me 4 weeks time. I will
No, it is.
take instruction. That is up to your. I also told what your lordship said. I can make prayer only. The court is to give or not. This is up to you.
Because of this special bench, it
I
is
fully understand.
difficult.
I fully understand.
uh,
Then your lordship said that your lordship will reject my prayer and I appoint some amicus curiae. That will be better. I asked for adjournment.
হচ্ছে কেন? না, সেই অর্ধেকটা টাকা করেন অর্ধেকটা করলে করেন হচ্ছে এভরিথিং নিজস্ব করে অর্ধেকগুলা করেন স্যার এটা আমার হচ্ছে লিস্ট কি প্রবলেম জীবনের ব্যাপারে জানি তো কিছু আমাদের গোটা বুঝছে আজ পর্যন্ত case there is no problem.
No, I can't say, but I can only give no instruction. I can pray. As your Lordship said, I prayed for it. Your Lordship refused. Then I can't. I will say that no instruction.
But one thing, Mr. Mishra, suppose even if they will engage somebody, immediately in 2 weeks time.
As such, we will also be taking to because we will be given paper book, we will see it, we will
You
prepare it.
say that yeah, mistakenly we commencing from 8 so that you can take your instruction and also get ready so that is the month of December month calendar. But we cannot grant this time because we know this bench is not taking for this. Can you get ready in that?
It is up to them.
So we are.
ସେ କଣ କହୁଥିଲେ ଆଗ socialist Russia ରେ the state was paying fees for both the parties. That was very convenient. But people overthrew the communist rule and they got the democracy or something.
We are fixing this matter on
15 December.
16th year.
16 December. I will try if he comes okay, otherwise I will not give no instruction. ପିଲାବେଳେ ଶୁଣିଥିଲୁ ସେ state bears the expenses of both the advocate, prosecution as well as the defense.
The report has been received from the IIC Sindhekala police station that all the 4 appellants are alive. The report is taken on record. Mr. H.S. Misra, the counsel appearing for the appellant, submitted that the matter was last listed on 3/3/2010, and since after more than 15 years it is being listed and it is to be taken for hearing, and he has not received the paperwork. You have not received the paperwork.
We have also.
And the state also
ready list ready hela par am paper book anu ajkal seta houni ache
and he has not received the paperwork. The paperwork may be supplied to him, and the matter may be listed 2 weeks after. Learning counsel for the state also made similar clear for supply of paper in view of the submission. Is this matter on 16th of December 2025 for hearing. The learning registry shall supply the paperwork not only to the learning counsel for the appellants but also to the learning counsel for the state during course of the day. Aji hi de rahe hai na. And let's move to intimation shall also be given by the IIC Sindhekala police station to all the appellants regarding fixing of the date of hearing on 16th of December 2025. Free copy of the order be handed over to the Land Council for the state for onward communication to the IIC Sindhekala.
And report compliance.
Yes.
And this order, this report compliance was the year
16th December 2025.
But I'm sorry, one matter I mentioned around 2 months back regarding persons who are out of service after getting the appointment of forester. The Lordship had in fact allowed that petition against the order of the tribunal.
Why not? Why not?
2 months your Lordship Pescar knows it.
No, this.
Yeah, because the district.
That is a separate bench, so please mention tomorrow. We'll do it. Yes.
That is it.
Item number 4. Yes.
Item 4.
Item number 4 and 5, my lord, the conducting counsel, Mr. Satpathy, my lord.
Pray for agenda, please. This is not good. 2004 criminal appeals were being listed, and the report has come. Not demon. He has been released on bail, and his whereabouts during my inquiry was missing from his village in law. His whereabouts was lost now. Before you report about Dawson, what we want? We want that whether he is alive or not, whether he is the only person in his family, whether he is not having contact with the family members, or even the neighbors, the friends? What sort of this report is? ତାଙ୍କ ଘର ଲୋକ ଆମ କଣ ଦରକାର ସେ ବଞ୍ଚିଛି କି ନାହିଁ ହଁ ସେତିକି ତ ଦରକାର ଆପଣ ଲେଖିଥିବେ ମିସିଂ କରୁଛି ଗାଁରୁ ହ୍ୱାଟ ଇଜ ଦିସ୍ ରିପୋର୍ଟ ଆଉ ସେ ମିସିଂ କରୁ କୁଆଡେ ଯାଇକିନି ଚେନ୍ନାଇରେ ରହୁ କି ବମ୍ବେ ରହୁ କି ଫରେନ୍ ଯାଉ वी आर लिस्ट कंसर्न अबाउट वी वांट दैट ही इज अलाइव तो से विषय तो तांग घर लोक कहि परिबे ना तांको साई पड़िसा बंधु बांधव कहि परिबे तो एतिकी असर्टेन करि कोन जेंति गोटे रिपोर्ट दे दोजन मिसिंग फ्रॉम हिज विलेज सिंस लॉन्ग there is nothing that the family members who are contacted and the family members have been expressed their ignorance about the whereabouts of the appellant. Nothing is there. Who report the So you have received the paperwork. No instruction matter. All the from Mr. Sarpoti matter. No, if you say no instruction, we can engage the counsel from the legal letter. Cannot adjourn the matter. Let it come day after tomorrow, my lord. Day after tomorrow it will come because he has to obtain that instruction. But don't seek for adjournment. Either you get prepared or say that I cannot argue the matter. We will engage somebody else from the panel. Look, a report has been received from IIC Bethnodi police station, wherein it is indicated that during inquiry, it was found that the appellant is missing from his village since long, and his present whereabouts is not known. There is nothing in the report that whether the family members of the appellant was there in the village, whether any the IIC has asked the family members, public neighbors, public friends of the appellant about his whereabouts. The Land Council for the state submits that the matter may be taken up day after tomorrow to obtain instruction regarding the well-being of the appellant. Put up this matter on 27th of November 2025. ତା ସାଙ୍ଗରେ କଥା ହେଇଯିବେ ହେଲା Land Council for the appellant is present. Yes.
Item 5.
Report कौन ଆସିଲା? Flag alive. Alive. ठीक है. Reading due to orders. So this is no problem. Paper book दिया. Among paper book. 3 persons were facing trial as it appears from the trial court judgment, and yeah. Not according to the other two.
Are convicted and one is acquitted. Two are convicted and one is acquitted. Logi, Kapul is acquitted.
While acquitting, ଲେଖା ହେଇଯିବ ନା? While acquitting accused Logu Kotuar from both the charges and setting him at liberty, I hold accused Jhodia Malik guilty under section 201 and accused Pratap Mohanto guilty under section 302-201. या तो
302 is one.
अच्छा ये वर्तमान याକୁ appeal କରିଛି ଜଣେ ଲୋକ ନା ଦି ଜଣ ଲୋକ ଜଣେ କରିଛି ପ୍ରତାପ ମାନେ ଯାହାକୁ 302
201 ରେ ତ ବୋଧେ ଅଣ୍ଡରଗ୍ରାଉଣ୍ଡ
201 ବାଲାର ଏଇଟା ସାତ
ନା ଯେହେତୁ ଇଏ ଅଛି ନା ସେସନ୍ସ ଅଛି ଇଏଟା 302 ଅଛି ତେଣୁ ତାକୁ 7 years କରିବେ।
One applying Pratap one applying Pratap नहीं नहीं ठीक है जी हमको जो ये काहे की आरोप पर फाइल कला तो मे बी
sentence for arrest for life
लाइक 302
and 7 years under
चारटा भी 207 वर्ष কিন্তু ফাইল তো করি
फाइल करने से अंडरग्राउंड 7 years तले ଥିଲା
ওটা কেবলকার ইয়েটা
যে এটা হচ্ছে
2003 ମାନେ ବର୍ଷ ଭିତରେ କମ୍ପ୍ଲିସନ ହେଇଗଲା ପରିବାର
ଚାନ୍ସ ନେଇ
So you are having the paper who with you?
No, my lord, that is my conducting counsel is Sapathi, my lord. May I pray one thing, like from Friday, my lord, because one matter is Thursday. Every Friday, my lord, in the week.
No, we can't have it on Friday. If one matter is on Thursday, we have to see. Sunday, 9
The fee is based on circumstantial evidence. Previous dispute ଅଛି 27 ରେ dead body recovery କରିଦେଇଛି, weapon of offense ଦେଇଛି, ଅନ୍ୟମାନଙ୍କୁ କହିଛି ଯେ deceasedକୁ ଖୋଜିବନି ଏବଂ ଧମକ ଦେଇଛି report lodge କରନି। ଏସବୁ accused statement ରୁ ଜଣା ପଡୁଛି these are the circumstances. So what do you say, Mr.? You have to collect the paperwork and get ready for hearing.
Yes, my lord.
Report କଣ ଆସିଲା ଯେ I like କିଛି ଲେଖିଛନ୍ତି ଏବେ? ଲେଖିଦିଅନ୍ତୁ item number 5 CRL number 392 of 2000. The IAC Bethnot Police Station has submitted a report which is dated 16/8/2025, wherein it is mentioned that during course of his inquiry it was ascertained that the appellant is now alive and stop. The land counsel for the appellant submitted that may be supplied with a copy of the paperwork. Upon filing, let the register supply the paperwork.
এটা কাহার রিপোর্ট আসছে?
IAC Bethnot case. The last question, it see 392 though.
Flat B.
392. Like
Oh, the 392.
like last question. And now Pratap Mahanta alias Pratap Chandra Mohan. Is alive and
That's not very aged then.
but now he's 59. Paperwork collector. So you get prepared. We are listing this matter on 2nd of December 2022. If you are getting 1 week time, paperwork there.
High Court Junction he was arranged retirement in his CG 18 December. CG Central Government in September, Sri Lanka, China. While in office, he bowed down his head at the table. Must have been dead. His men October 3 and from must play. Not out of people. People can be and I believe that
Item 6.
Item 6.
Next report on the basis of last report, we have to follow up on the report. The first report will be
Appellant has been directed to be released on bail and use sought for time to for being report.
or not sufficient time. It prepare short action.
There are
These
two
are
appeals. Two appeals.
Hmm.
In each appeal, there is one appellant.
Charity tag ହେଇଛି
Huh?
ଆମ ପାଖକୁ ଯୋଉ paper
ନାଇଁ ଚାରିଟା ଟ୍ୟାଗ ହେଇଛି
ଅଣା
CRL 90 CRL 89 of 2005
ଆଜ୍ଞା।
ସରି ଯାଇଛି ନା କଣ
ଗୋଟେ 86
ମାନେ
93
90 86 89 1993.
ये this petitioner
So what about this 89 2005? It was showing.
ନା ନା ସବୁ ଗୁଡା ପେଣ୍ଡିଂ ଅଛି।
So ତା ସାଙ୍ଗେ company କି
ଏଇଟା ଟ୍ୟାକ୍ସ ଏମିତି ସବୁ ସେପାରେଟ ଟ୍ରିଟ୍ କରିବା କଥା।
ୱିଥ୍ କରିକି ସେଟା
ତା
separate
ଭିତରେ
କରିଦେବେ।
ତା ଭିତରେ ପୁରେଇ ଦେଇଛନ୍ତି। 89 ଟା ଦେଖି
89 ଟା hard ଥିଲା ନା consider the effluent as well as considering presence of effluent say बच्चा बोला and directed during pregnancy of the sentences passed against him by the learning that of its success in respect of the limit suspended and he shall be released from the
ବେଲ୍ ହେଇଯାଇଛି।
बेल 5/1/2006
So that means you want to obtain
93.
instruction
93
ଯୋଉ ଚାରିଟା ଯାକ କ୍ରିମିନାଲ ଅପିଲ ଯୋଉ ଆପେଲାଣ୍ଟ ଅଛନ୍ତି as it appears number of persons faced trial
17%.
89 ରେ ଯିଏ charge face କଲା trial face କଲା he was 78 years then in 2005
65
तो
75
ଏବେ
70
17ରୁ କଣ 13ଟା କଣ ଖଲାସ ହେଇଗଲେ ନା କଣ? ମାନେ 4 ଜଣ ଯଦି ଫାଇଲ କରୁଛନ୍ତି 4ଟା କ୍ରିମିନାଲ ଅପିଲ what happened to the other 13?
Lordship, in CRL 86 there is 3 appeal.
अच्छा
huh?
CRL
86 of
86 ଟା ବାହାରିଥିଲା।
ନା ନା ନା
86 ରେ ହଁ ଭିକାରୀ ମହାପାତ୍ର ପ୍ରଶାନ୍ତ ମହାପାତ୍ର ଗୋକୁଳ ମହାପାତ୍ର।
ନା ତ 90 ରେ ତ ଆହୁରି ଅଛି 90 ଟା କିଏ 90 ଟା କୃଷ୍ଣଚନ୍ଦ୍ର ସାହୁ ଗୁରୁବାରୀ ସାହୁ ଜୟନାଥ ପରିଡା ଗୋକୁଳ ବେହେରା ରମେଶ ପ୍ରଧାନ ମଦନ ପରିଡା
How many persons faced trial and how many of them have been found guilty?
altogether 17 से face trial
हाँ
ତାପରେ କଣ ହେଲା? ଜଜମେଣ୍ଟ ରେ କଣ ହେଲା? ଏଇ ପେପର ବୁକ୍
6 accused persons, Lordship, acquitted. 6 accused
11% were convicted, 86% acquitted. Page 828 internal page, running page 83.
Running page
83.
83 पूरा। Trial court judgment of page
Trial
number
page 28. Internal page 20.
28. ये गोटे judgment ରୁ arise କରୁଛି ତ?
ଆଜ୍ଞା।
so 17 accused persons were there Then we go to 17 accused persons were there
criminal appeal ରେ ହଁ ଏଠି ତ ST ରେ ହେଲା 17 17ରୁ ଖଲାସ ହେଇଛନ୍ତି କେତେ?
6 ଜଣ।
କୋଉ ପାରାଗ୍ରାଫ ଟା ପହଞ୍ଚି
42.
पेपर बुक पेज नंबर केते
27.
पीछे में पूरा जो है
82
आरएम इज 56
82 82 82 para 41
42
para 42.
in the result I
Conviction
find
part
that there is no
43.
sufficient evidence against the accused ଏଟା ହେଲା 1 2 3 4 5 6 ଆଚ୍ଛା 6 ଜଣ ଖଲାସ ହେଇଗଲା ତେଣୁ ବାକି 11 ଜଣ 1 2 3 4 5 6 7 8 9 10 11 11 ଜଣକୁ ବାକି 307 by 149 ରେ ଇଏ ହେଲା ଏବଂ
ଅରକ୍ଷିତ ହେଲା 302.
attempting to call ରେ ହେଲା
6 ଜଣଙ୍କର ସେପାରେଟ କନଭିକ୍ସନ ପାରା 43 ଲାଷ୍ଟ ପାର୍ଟ ରେ
ନାଇଁ ନାଇଁ ସେଇ ଯୋଉମାନଙ୍କୁ କଲେ ତାଙ୍କୁ ବି 307 149 ରେ
ହଁ ସେ
not guilty 302.
and acquit them under 235 କାହାକୁ
not found guilty 307 149.
କାରଣ 302 ରେ 1 2 3 4
আচ্ছা
5 6 7 8 9 10 11 ସମସ୍ତଙ୍କୁ ହେଇଛି 302 148 324 by 149 307 by 149 ହେଲା ସମସ୍ତଙ୍କୁ ଇଏରେ ହେଇଛି ଆଉ ତା ଛଡା in addition to
ହୁଁ
that 302 separately ଇଏ ହେଇଛି ଅର୍କିତକୁ ହେଇଛି କୃଷ୍ଣକୁ ହେଇଛି 307 with aid of 149 all have been found guilty under 302 that is in paragraph number 43 ଯଦି 11 ଜଣକୁ ହେଲା ସମୁଦାୟ ତାହେଲେ କୋଉ appeal ରେ କେତେ ଜଣ 86 ରେ କେତେ ଜଣ
86 ରେ 3
3 accused person.
3
Yes.
ଭିକାରୀ ପ୍ରଶାନ୍ତ ଗୁପ୍ତା
ଠିକ ଅଛି ତାପରେ 89 ରେ କେତେ appeal memo ଦେଖନ୍ତୁ
ଜଣେ
ଜଣେ
ବଚ୍ଚା ଭଲ
ତାପରେ 90 ରେ
90 ରେ ହେଲେ ଚାରି ଜଣ 1 2
ଜଣ।
3 4 5 6
6
ଜଣ
ଜଣ
6 ଜଣ ଆଉ ବାକି 93
ଜଣେ
ଜଣେ
93 ରେ ଜଣେ
3 1 4 4 6 10 11 ହଁ 11 ହେଇଛି ଏଇଟା କଣ ଏଇଟା ହେଇଗଲା 11 ଠିକ ଅଛି so you argue the matter what about the well-being କଣ
ସେ ଖାଲି 93 ରୁ ୱେଲବିଂ ଟା
93 ର ଖାଲି ବାକି ଅଛି
ଲାଷ୍ଟ ଚିଠିରେ 93 ରୁ
ନାଇଁ ନାଇଁ ଏଗୁଡାକ ଆସିଗଲାଣି 86 89 90 ର ଯୋଉ ଆପଣ
93 ରେ ଗୋଟେ ଅର୍ଡର ହେଇଛି ତାପରେ
ନାଇଁ ଅର୍ଡର ସିନା ହେଇଥିଲା କିନ୍ତୁ ଆସିଲାଣି ବାକି
ଲେଟର ୱିଲ୍ ବି ଇସ୍ୟୁଡ୍ ଇଟ୍ ମେ ବି ସମାପ୍ତ
ଆପଣ ତାମାନେ well-being reports ଏ କୌଣସି criminal appeal ରେ obtain କରିନାହାନ୍ତି what is your instruction
So we do not have any instructions regarding the well-being of one of the appellant at that time is 71 years old.
ସେଇଥିପାଇଁ ତ ପଚାରୁ
and 1 year old is we can very well see you are not in contact with the persons and you are telling about them this we can see he was 71 then
71
in 2005
ପଛ ବଳ ହଉଛି 78
78
78 ye 71 ବିଚାରି ମା
ଇଏ ଯାଇଥିବେ ବହୁତ 20 ବର୍ଷ ହେଇଗଲାଣି ମାନେ ତାদের ଯାଇଥିବେ
all cases will call for it.
badly required
uh,
individual secretary
Individual cases.
criminal appeal number 93 of 2005 ରେ ଲେଖିବେ order ଟା it appears that criminal appeal number 89 of 2005 and criminal appeal number 90 of 2005 are connected to this criminal appeal, but it has to be shown separately in the cause list, indicating the name of the Learning Council on the next date. And all these three matters should also be listed with CRL number 86 of 2005, which is also connected to it. From the trial court judgment, it appears that 17 accused persons face trial for various offences, including the offense under section 302 of the Indian Penal Code. And the London trial court has acquitted 6 of the accused persons, and out of the rest 11 accused persons, 3 have filed CRLA number 86 of 2005, 1 has filed CRLA number 89 of 2005, 6 have filed CRLA number 90 of 2005 and one has filed CRLA number 93 of 2005. All the appellants in the 4 appeals are on bail granted by this court. The Learned Counsel for the state, though, was asked to obtain a well-being report in respect of the appellants, but he has sought for some more time to obtain instruction in that respect. Release this matter on Kebe Rakiba 9 tarikh Rakiruchi, you are getting 2 weeks time almost. 9th of December 2025. Let the Learned Counsel for the state obtain the well-being reports of all the 11 appellants in these 4 appeals, and a free copy of the order be handed over to the Learned Counsel for the state. In all these 4 matters, it belongs to Mr. Dhawal chamber.
No, it's only CRL number 86 belongs to.
Only 86.
Yes, sir.
So ଏଇଟା ତ ହେଲା ଅରକ୍ଷିତ ମହାପାତ୍ର ହେଲା ପିକେ ସିଂ, ବାକି 89 ଟା କାହାର?
93 DP ଧର।
अच्छा 89 ଟା ହେଲା DN दास, DC प्रधान, HK हाथी। ଆଉ ଗୋଟା କୋଉଟା ମିଷ୍ଟର ଦୀପି ଧଳଙ୍କର?
93 ବି ଶୋ କରୁଛି DP ଧର।
90?
ହଁ 93 19/2/2005।
93 ଟା ମନା କରୁଛନ୍ତି ସେ, ପିକେ ସିଂ ଲେଖା ହେଇଛି 93 ରେ, ପିକେ ସିଂ ପି ପଣ୍ଡିତ। ଆଉ 90 ଟା ହଉଛି 90 ଟା ବାର କଲା। ହଁ 90 ଟା DP ଧଳ ଅଛି। ତ ଆପଣଙ୍କର 90 plus 86, these are 2 matters which belong to your channel.
Yes.
But even if nobody appears on that day, you ask Mr. Dhar to get prepared for the other appellants also, so that we can engage him as the learned amicus curiae and hear.
Yes,
It's not that for non-appearance of the counsel in the other criminal appeals will adjourn the matter. You have collected the paperwork.
today.
The Learned Counsel for the appellant. What is your good name?
Abhishek Pradhan.
Abhishek Pradhan, who is an associate of Mr. D.P. Dhar, senior advocate, submits that during the course of the day, he may be supplied with a copy of the paperwork for preparing the it is matter for all the good, let the registry supply the paperwork copy to the Learned Counsel for the appellant.
Item 7.
Yes, well-being report.
Yes, Nirmal, may I present it for therefore tomorrow, because we are sending the letter to the IAC, but order sheet so that on 13/10/26 they are not released on bail. So I can call the
Who has not released on bail?
order of 13/10/6 ଅନୁସାରେ matter maker, we are not inclined to release the appellant on bail at this stage. The paperwork will be prepared within the potential. There is no order. So we can call the counsel.
So ये नहीं तो either दीटा जिनिष ହେଇପାରେ premature release ହେଇଥିବ। ସେ କଣ ଗାଁରେ ବୁଲୁଛି ଏଇକା?
ନାଇଁ
ଓ ନେଇନାହାନ୍ତି instruction. Who jail? You are right that his bail application was last time rejected on 13/10/2006. So then it came on 18/10/2025.
Below to Sundargarh.
Session just Sundar.
Council nahanti.
যোগেন্দ্র মহান্তি ভি নামা আছে ভাই প্রতিম যোগেন্দ্র মহান্তি
No, ঠিক আছে, but you give a ask him to appear that you superintendent କୁ କୁହନ୍ତୁ ଜଣା ପଡିଯିବ ନା ହେଲା, we are just deferring this matter. Ask the Sundargarh superintendent, district jail Sundargarh ହେଲା, এটা fast over କରୁଛୁ ଭିତରେ ଥିଲେ ସେ ରିପିଟ୍ କରିଥାନ୍ତା ବେଲ୍, କିଛି ଟୋଟାଲ ନାହିଁ ମାନେ ବୋଧେ ପଳେଇ ଯାଇଛି, ସେ ଦେଖିବେ ଆସୁ ପାସ୍ ଓଭର କରୁଛୁ। Yes, sir.
Item 9.
9 the report
Premature release ହେଇଛି,
premature
single appellant.
appellant singing but the judgment copy
Judgment showing 5 appellants.
3 appellant
No. 5. Not appellant. Judgment in the lower court, 5 accused persons were there. Acquittal कितने हैं?
Ram Singh Iraj Darka
এটা कितने এটা CRA item 9
39 by 20 there are 39 by 20 the 3 Raditas Ram Singh
there are 3 accused persons.
the office notes are the single that
Ram Singh, Jujhar
and Kira Darka Koira
And all of them have been found guilty under section 302 by 34, 376 2G and also 201 by 34. ତେଣୁ ବର୍ତ୍ତମାନ ଏଇଟା ଏଇ ଜେଲ୍ କ୍ରିମିନାଲ ପିକ୍ଚର ହଉଛି ଜଣଙ୍କ ପାଇଁ
appeal ହେଇଛି
ହଁ ଠିକ ଅଛି, so we will pass the order in this jail criminal appeal. ଲେଖନ୍ତୁ this jail criminal appeal has been filed by the appellant Kaira Jarika. A report has been submitted by the Superintendent District Jail Baleshwar, wherein it is indicated that the appellant has been released prematurely on 19/11/2025 as per the order of the government. The stop. In view of such report, the jail criminal appeal is forth. Next, 10 report question.
11 is come to 11. 11 item. There are a batch of other appeals were filed. All those cases are abated because of death. This one is left. The paperwork may be supplied.
No, there are
orders have been passed.
CRL 140 ଆଉ disposed of cases ଲେଖାଏ। ଟିକେ ଦେଖିଦବା 140 ଟା ମାର୍କ ନା ଏଟା ଡେଟ୍ ଥିଲା, ତାପରେ ଆରଟା ହଉଛି 177 ବି ଡେଟ୍, ଠିକ ଅଛି। ତେଣୁ ଏ ଦିଟା ଅପଡେଟ୍ କରିଯାଇଛି, ବାକି ରହିଲା ଏଇ ଗୋଟେ ଅଛି 194। ଆପେଲାଣ୍ଟ କେତେ ଜଣ?
2 ଜଣ।
କୀର୍ତ୍ତନ ଆଉ ପ୍ରଫୁଲ୍ଲ, they are alive.
The report is there. Kirtana has left the village since long.
mean, he is found absconding since when?
ସେଇଟା ଦେଇନାହାନ୍ତି।
No, Noida police has requested to execute the non-bailable warrant of arrest by letter dated 4/9/25. এটা কাহার order?
এটা আমি ଯୋଉ ବେଲ୍ ଦିଆ ହେଇଛି ତାଙ୍କୁ ବୋଧେ
ସେ ଆସିନି।
ଆସିନି ବୋଲି
ତ 4/9 ର ତ order ନାହିଁ କିଛି।
ହଁ
Order ତ ଆମର କିଛି ନାହିଁ। ତ
ଏନବିଡବ୍ଲ୍ୟୁ ହଁ ହେଇଛି ଅଛି ଏନବିଡବ୍ଲ୍ୟୁ
କୋଉ order ରେ?
ଅର୍ଡର ଡେଟେଡ 25/6/2014।
14?
ऑर्डर नंबर 22 ऑर्डर नंबर 22 25/6/2014। क्रिमिनल अपील 194 तो ऑर्डर नंबर 22
वारंट ऑफ अरेस्ट
25/6/2014।
Issue warrant ever.
Appellant number 1 and so on so and appellant number 2 so on so
ତାପରେ ଜଣେ ମରିଗଲା। One has expired. After that. ହଁ ଆମେ already 23 ନରେ କଲୁ ପୁରା order। 23 ନରେ order ହେଲା।
only one has left appellant number 1
Appellant number 1 Kirtan Naik is concerned the apostate letter is 10/9/25 indicates that warrant of arrest issued against appellant number 1 has not yet been executed.
Appellant number 2 expired
Appellant number 2
that is order dated 23/9/2025 since none of the near relatives so and so has filed in his ତେଣୁ ବର୍ତ୍ତମାନ ହଉଛି କେବଳ appellant number 1 ର ନିଆ appellant number 1 has been mentioned to be 62 years. Let the Land and Council for the state obtain the specific instruction regarding the well-being of so and so. ଏଟା କଣ ହେଲା ସେ ରିପୋର୍ଟଟା ପ୍ରେସ୍ ରିପୋର୍ଟ ମଗାଇଥିଲା
ସେଇଟା ଆସିନି that's why
13/11/25 order report ଆସିଛି ପରେ ଗୋଟେ ଦେଶୀ
ଅଛି ତ flag jet
flag jet
Kirtan Naik could not be traced out after several days. AAC penalty so on so is further instruction to expedite the execution of the reminder has been sent so on so on. Okay, so there is no problem. So ସେ NBW ଯାଇଛି ତେଣୁ ଜଣକ ପାଇଁ ହିୟରିଂ ହବ
ଆଜ୍ଞା I pray that paper book may be
you are appealing
And for on behalf of Mr. Nandi, he is the amicus curiae. He was here. He was having high fever, so he just left place for him. Sure, maybe day after
you
tomorrow.
are sitting here right?
So he's having high fever, so he just left. He was not feeling.
ସେସନ୍ ଜଜ୍ ରିପୋର୍ଟ ଦେଇ ଦେଇଛନ୍ତି ଯେ NBW ଏକ୍ଜିକ୍ୟୁଟ ହେଇପାରିଲାନି ତା ଉପରେ appellant number 1 ଉପରେ କିନ୍ତୁ ଆପଣଙ୍କୁ କୁହାଯାଇଥିଲା ଯେ ଆଣିବା ପାଇଁ ୱେଲବିଂ ରିପୋର୍ଟଟା ତେଣୁ ବଞ୍ଚିଛି କି ନାହିଁ ସେ ରିପୋର୍ଟଟା କିନ୍ତୁ ଆପଣ ଦେଇନାହାନ୍ତି What is your instruction about
the short for some time they have written then I will remind
Welcome to the Learned Counsel for the Learned Amicus Curie, Mr. Mahanti is present. The report has been received as per the order dated 23/9/2025 from the Learned Session Judge Nayagar, which indicates that the non-bailable warrant of arrest, which was issued by this court for arrest of appellant number 1, Kirtan Nayak, could not be executed. And stop. And the instruction has been received from the IIC Tamati police station. The Learned Counsel for the state was also asked in the aforesaid order to obtain instruction regarding the well-being of appellant number 1 through his relatives. The Land Council submits that the matter will be taken up next week for the so that necessary instruction will be obtained. Put of this matter on Thursday. Next Thursday. Oh, now put of this matter on 4th of December 2020. Yes.
A copy of that report of session judge making provide so that I am conveyed to the SP concerned. The report of the session judge.
Free copy of the order be handed over. So also the report of the district judge Nayagar dated 31/2025. Copy be handed over to the Learned Council for the state.
13/11. 13/11. 13/11.
13/11/25.
13/11/25. Other Lakhi no report has been received from office of the SP Nayagar.
That's why
However, the IIC intimated that this could not be executed.
God bless you.
Next. Item? Asile.
Lordship. Finally taken off Thursday, Lordship. Personal difficulty, Lordship. On the basis of oral lying declaration, conviction order, Lordship passed, Lordship. Finally taken off Thursday, Lordship.
Wait. So one explanation was called for that. Unconditional apology. Inside on explanation data. You is missing. You are going to ask for the order dated 6/11/2025. explanation has been received from Vidular Turu, ASO, type and paperwork section. Shakti Swarup Sahu, Assistant Section Officer, Central Issue Section, and Srimati Binapani Sasmal, Rapist, Type and Paperwork Section. And all of them have faked unconditional apology for the inconvenience caused, which has been reflected in the order dated 6/11/2025. The explanation offered by all the three are accepted. Stop. Yes, one.
Yes, first day. I personal difficulty that.
One personal difficulty.
First day कर दे.
ଦି ଜଣ ଯାକ ବଞ୍ଚିଛନ୍ତି?
ଆରେ କିଛି ଶୁଣାଣି ହେଇଥିଲା ପ୍ରୋସିକ୍ୟୁସନ ୱିଟନେସ୍ ଗୁଡାକ ପଢା ହେଇଛି ଏଥିରେ ଆଉ ଫର୍ଷ୍ଟ ଡେ ଆସିବି ଆଉ
Wait, is it a part-heard matter? A part-heard. part-heard ଲେଖା ହେଇଛି ଆପଣଙ୍କର order dated 6/11/2025 ରେ ଲେଖା ହେଇଛି. Are Miss Mandakini Kundal and an amicus curiae and Swansul and an additional standing counsel for state in part. 6 some time for preparation of the case. We will argue it on Thursday.
Yes.
Miss Mandakini Panda and an amicus curiae for the appellant is present. Source Mr. Sarachan Bhutpand and an additional standing counsel for the state. Ms. Panda, request for an adjournment till the act of tomorrow. Is this matter on 27th of November 2026?
The name of Mr. Devi Prasad kindly delete.
Which one?
In item
the amicus curiae.
Acha. The name of Ekananda or Jenai? The name of Mr. Devi Prasad, Mrs. Ekananda, Mr. Ekananda and Jenai shall not be reflected in the cause list transfer. Hello? Yeah.
item number 12, for an adjournment.
You know what?
Also, Mr. Mapache is out of.
You are the matter. Give the paper.
ଦୁଜଣଙ୍କର ହେଇଛି ଟ୍ରାଏଲ ସରିଯାଇଛି ଏଇଟା ସ୍ପ୍ଲିଟ୍ ହେଇକି ହେଇଥିଲା ଏଇ ଯୋଉ ଏକ୍ୟୁଜର against two others ସେମାନେ
ହଁ 247 ତ
ହଁ 247
247 ଜଜମେଣ୍ଟ ହଉଛି ଆଜି it appears 3 ଜଣ ହଉଛନ୍ତି
ପରେ ସେମାନେ ଆସିଛନ୍ତି ଆସିକି ଫେସ୍ କରିଥିଲେ
3 ଜଣ ତିନି ଜଣ paragraph number 12 ରେ ଦେଖଉଛି page number 7 internal page the trial for judgment of page number 7 paragraph
in the result
I find that accused persons and more alias Hemant Kumar Pradhan out of the
not
ତେଣୁ ତାପରେ ହେଇଛି 302 ରେ
ବସନ୍ତ କୁମାର ପଡେ reliance ଦାସ।
ହଁ ସେଇ ବସନ୍ତ ହିଁ ଜଣ ଇଏ କରିଛି ଆଉ ପେପର ମୋଡ଼ିଲେ।
It's weekend.
We read the FIR.
And after I don't have I don't have my brief with me.
Data point. Yes.
Is unable to read it.
Why? You cannot read Odia.
Clearly.
Do you read?
You read.
We'll see.
ମୁଁ ଶ୍ରୀ ଗୋପାଳ କୃଷ୍ଣ ସେନାପତି ପିତା
ସୁରତ ଚନ୍ଦ୍ର ସେନାପତି
ସୁରତ ଚନ୍ଦ୍ର ସେନାପତି ଗ୍ରାମ
କସରଦା ଥାନା ନିଆଳି ଜିଲ୍ଲା କଟକ ଲେଖି
ଜଣାଇବାରେ ଅଭିପ୍ରାୟ ଏହିକି ଯେ ଆଜି ତାରିଖ 31/7/97 ଗୁରୁବାର ଅନୁମାନିକ 30 ମିନିଟ ସମୟରେ ମୁଁ ଖାଇସାରି ଆମ
ଘରୁ ଗାଁ ଛକ ଆଡକୁ
ଆସୁଥିଲି। ହଠାତ୍
ଚିତ୍କାର
ଶୁଣି ମୋ ପାଟି
ହେଉଥିବା
ଜାଗା ଆଡକୁ ଦୌଡ଼ି ଯାଇ ଦେଖିଲି ଅଡ଼ଶପୁରକୁ ଲମ୍ବିଥିବା ରାସ୍ତା ଉପରେ ମୋର କକା ସୁକାନ୍ତ
କୁମାର
ସେନାପତି ଆମ ଗ୍ରାମର
ମାନେ ଡିସିଜ୍ଡ କୁ ଆମ ଗ୍ରାମର
ପଞ୍ଚାନନ ପ୍ରଧାନଙ୍କ ପୁଅ
ବସନ୍ତ ପ୍ରଧାନ
ହେଲା ଆପେଲାଣ୍ଟ। ଗୋଟିଏ
ମହାପାତ୍ରଙ୍କୁ
ଗୋଟିଏ ଫାର୍ସା
ଧରି ପ୍ରଫୁଲ୍ଲ ମହାପାତ୍ରଙ୍କ ପୁତ୍ର ସୁଶାନ୍ତ ମହାପାତ୍ର
ସୁଶାନ୍ତ ମହାପାତ୍ର ଆକ୍ୟୁଟର
ଖଣ୍ଡାଧାରୀ ଓ ସୁର ମହାପାତ୍ର
ଖାଲ
ପୁଅ ଯାହାଙ୍କୁ ମୁଁ ଚିହ୍ନେ କିନ୍ତୁ ନାମ ଜାଣିନେ ଗୋଟିଏ ଭୁଜାଲି ଧରି ମୋ କାକାଙ୍କ ମୁଣ୍ଡ ଓ ବେକକୁ ଅତି ନିର୍ମମ ଭାବେ ହାଣୁଛନ୍ତି ଏବଂ ମୋ କାକା ମାରି ପକାଇଲେ ବଞ୍ଚାଅ ବୋଲି ପାଟି କରୁଛନ୍ତି। ମୁଁ କିଏ କୁଆଡେ ଅଛି ଦୌଡ଼ି ଆସି ମୋ କାକାଙ୍କୁ ହାଣି ପକାଇଲେ କହି ବ୍ୟାଙ୍କ ପର୍ଯ୍ୟନ୍ତ ଦୌଡ଼ି ଆସି ବସନ୍ତ ସୁଶାନ୍ତ ବାବୁଙ୍କ ପୁଅ ଘଟଣାସ୍ଥଳରୁ ନିଜ ନିଜ ବାଣାସ୍ତ୍ର ଧରି ଅଡ଼ଶପୁର ରାସ୍ତାରେ ଦୌଡ଼ିଲେ। ମୁଁ ଘଟଣାସ୍ଥଳକୁ ଯାଇ ଦେଖିଲି ମୋର କାକା ରକ୍ତ ଜୁଡୁବୁଡୁ ହୋଇ ରାସ୍ତାରେ ପଡି ସୁକୁସୁକୁ ହେଉଛନ୍ତି। ତାଙ୍କ ମୁଣ୍ଡ ଓ ବେକରେ ଗଭୀର କ୍ଷତ ଚିହ୍ନମାନ ଅଛି ଓ କ୍ଷତରୁ ପ୍ରଚୁର ରକ୍ତସ୍ରାବ ହେଉଛି। ଏହି ସମୟରେ ଆମ ଗ୍ରାମର ଜଗୁ ସାହୁ ପାଟି ଶୁଣି ଆସି ମୋ ପାଖରେ ପହଞ୍ଚିଲେ। ଜଗୁ ସାହୁ କକାଙ୍କୁ ଏପରି କଣ ହେଲା ବୋଲି ପଚାରିବାରୁ ମୋର କାକା ଅତି କଷ୍ଟରେ ବସୁ ପ୍ରଧାନ ଫାର୍ସାରେ ଟୁକୁନା ମହାପାତ୍ର ଖଣ୍ଡାରେ ଓ ସୁର ମହାପାତ୍ରଙ୍କ ପୁଅ ଗୋଟିଏ ଭୁଜାଲିରେ ତାଙ୍କୁ ହାଣି ପକାଇଲେ ବୋଲି କହିଲେ।
ଜଗୁ ସାହୁ ହଉଛି ପିଡବ୍ଲ୍ୟୁ କେତେ? ଜଗୁ ସାହୁ ପିଡବ୍ଲ୍ୟୁ 5 ଆଚ୍ଛା। ଓରାଲ ଲାଇନ୍ ଡିକ୍ଲାରେସନ ଓକେ।
ଓ ଭୁଜାଲିରେ ହାଣି ପକାଇଲେ ବୋଲି କହିଲେ। ଏହାପରେ ଆମ ଗ୍ରାମର ସୁବାସ ମହାପାତ୍ର, ଉମେଶ ମହାପାତ୍ର, ନୃସିଂହ ମହାପାତ୍ର, ବ୍ରଜକିଶୋର ମହାପାତ୍ର ଆହୁରି ଅନେକ ଲୋକ ଘଟଣାସ୍ଥଳରେ ପହଞ୍ଚିଲେ। ମୁଁ ଆମ ଗାଁକୁ ଆସିଥିବା ଶ୍ରୀକୃଷ୍ଣ ଷ୍ଟୋରରେ ମୋ କାକାଙ୍କୁ, ମୋ ଖୁଡ଼ୀ ମଞ୍ଜୁରତ ସେନାପତି, ଜଗୁ ସାହୁ, ସତ୍ୟବ୍ରତ ମହାପାତ୍ର ଆଲିଆସ ବ୍ରତ ମହାପାତ୍ରଙ୍କ ସହ ହରସପୁର ଡାକ୍ତରଖାନାକୁ ଧରି ଆସିଲେ। ହରସପୁର ଡାକ୍ତରଖାନାରେ ଡାକ୍ତର ଆଉ ପରୀକ୍ଷା ନିରୀକ୍ଷା କରି ମୋ କାକାଙ୍କୁ ମୃତ ବୋଲି କହିଲେ। ବସନ୍ତ ପ୍ରଧାନ, ସୁଶାନ୍ତ ମହାପାତ୍ର ଓ ସୁର ମହାପାତ୍ରଙ୍କ ପୁଅ ଫାର୍ସା ଖଣ୍ଡା ଓ ଭୁଜାଲିରେ ଆକ୍ରମଣ କରି ମୋର କାକା ସୁକାନ୍ତ କୁମାର ସେନାପତିଙ୍କୁ ମାରି ଦେଇଛନ୍ତି। ଏହି ମୋର ଏତଲା ତଦନ୍ତ ହେବ। ପ୍ରକାଶ ଥାଉ କି ଘଟଣାର ପ୍ରାୟ 8 ଦିନ ପୂର୍ବରୁ ଘନ ଭୋଇ ଆଗରେ ବସନ୍ତ ପ୍ରଧାନ ଓ ତାର ବାପା ପଞ୍ଚୁ ପ୍ରଧାନ ହଟକିଶୋର ଖଟେଇଙ୍କ ଆଗରେ ମୋ କାକାଙ୍କୁ ମାରି ଖତମ କରିଦେବ ବୋଲି ଧମକ ଦେଇଥିଲେ।
So why these two were acquitted? Dying declaration ବି ଅଛି, ଆଇ ୱିଟନେସ୍ ଯାହା ଜଣା କହିଛନ୍ତି ସେ ଦି ଜଣ ପାଇଁ ଛାଡି ଦିଆଗଲା। ଦେଖିଲେ ରିଜିନ ଦେଖିଲେ କୋଉଠି କଣ ଦିଆହେଇଛି। ଏକ 4, 5, 6 they are the eyewitnesses to the occurrence.
But judgment seems at para 4 prosecution relies on evidence of schedulers 4, 5 and 6 who are eyewitnesses.
एक मतलब देखिए जो क्रॉस जो accused statement को जाना पड़ती है। 1, 4, 5 और 6 they are the eyewitnesses and କହିଲେନି କି ସପୋର୍ଟ କଲେନି ନା 1, 4, 5, 6 एक को ଆସିଲା ଦେଖିବା
Period one to eyewitness and information.
ଦୁଇ ବି ତ କରୁଛୁ
Para 10 of the
So we want that why those two have been acquitted. Para 10 ne.
Para 10.
अच्छा देखिए. It is from the FIR and at least appears that evidence is similar in nature. Okay, read out on perusal of the
evidence on record. There is absolutely no evidence against the accused Hemanta Kumar Pradhan and Panchanana Pradhan so as to implicate them in connection with the alleged occurrence. There is no evidence whatsoever against the above two accused persons, Hemanta and Panchanana, to have assaulted or to have taken any part to cause the death of the deceased.
How do you see it?
In the case against the accused persons, Hemo alias Hemanta Kumar Pradhan and Panchu alias Panchanana Pradhan could not be proved by prosecution in connection with the occurrence of this case.
So you come to that, let us see that eyewitness. How he has come to such a finding? Read out one question. One is an eyewitness.
I am also known as Matthew. I know the accused person Panchanana Pradhan, Hemanta Pradhan and Vasanta Pradhan. I know the deceased Sukanta Senapati died on 31/7/97. On 31/7/97 Thursday at 1 p.m. the accused Vasanta along with his friend Tukuna alias Sushanta and Kanu Mahapatra killed my uncle Sukanta Senapati by means of Khatsa, Bhupeli and sword. On 31/7/97 at about 1:30 p.m. after taking my food, I came out of my house and went to a chako. When I arrived near the chako, on hearing a sound of
ମାରି ପକେଇଲେ
coming from my left side, I saw I saw towards the Oraspur roadside from the Chako that the accused Basanto along with Tukuna Mahapatra alias Susanto and Kanu Mahapatra were assaulting the deceased, which were my uncle,
By means of
Farsa, Bhujali and Sur. On hearing the assault, I shouted, accused Basanto was assaulting Sukanto Senapati by means of Farsa. Tukuna alias Susanto was assaulting by means of sword, and Kanhu Mahapatra was assaulting by means of Bhujali to Sukanto Senapati. When I went near to the deceased, the accused persons, on seeing me, went away towards Oraspur. I arrived near my uncle and saw my uncle Sukanto, who had sustained bleeding injury on his person. Soon after my arrival, witness Jogu Pidul 5 arrived. Jogu Sahu asked my uncle Sukanto as to who had assaulted him, to which my uncle told that accused Basanta by means of Farsa, accused Kanhu by means of Bhujali, and Tukuna by means of sword have assaulted him. Then I told Jogu Sahu to remain present near my injured uncle, and I came to the village to take a record. I saw bleeding injury on the head, neck, and left shoulder, and on body of my uncle, uh, and on the body of my uncle. I took my uncle Sukanta in a trekker along with his Manjulata Senapati, Satyavata Mahapatra, Japu Sahu, Rajakishore Mahapatra to Oraspur Hospital. On arriving at the hospital, the doctor, on examining my uncle, declared him dead. Then I, along with the Samir Senapati, Braja Mahapatra, went to the nearby police station to report. I scribed my report by purchasing a paper from a bookstore and presented the report before the OIC near PS. After receiving the FIR, the OIC examined me, and thereafter we came to Oraspur and saw the dead body of the deceased Sukanto, and police prepared inquest report where I give my signature. Exhibit 1 is the FIR, whereas in Exhibit 1 by 1 is my signature. Exhibit is the inquest report prepared by police, where I gave my signature Exhibit 2 by 1. After inquest, the dead body was sent for postmortem examination to hospital. Jogu alias Jogu Sahu and Venudhar Swain, along with a constable, went with the dead body. On the following day, I took one pillow, one thread, and one ring containing 3 keys and 1 finger rings in my Jima, as for Jima no Exhibit 3, where I gave my signature Exhibit 3 by 1 and 3 by 2. Prior to the date of occurrence, the accused Panchanano had threatened my uncle to kill in presence of the Hattokhati, and accused Basu threatened my uncle to kill in presence of Ghanapuri. Hatto and Ghanna came and informed me. Then I informed my uncle. My kaka told that they will not do anything to him. Prior to 2 months of the occurrence, then I meet accused Basanta near his house. He told that a big head will be taken from the village. When I asked as to why, he told that there was a dispute and he had informed that there will be assault, for which the big man will be killed. Then I told not to do such act. Any conclusion, madam?
Yes, of course.
In conclusion, there is no Oda in our village. Our village consists of about 400 to 500 houses, having 4,000 to 5,000 population. My house is situated in the side of the village. My family consists of 5 members, and my uncle deceased Sukanta family consists of 6 members. The deceased is the brother of my father. It is a fact that we all are staying jointly in one house. Subhranshu Mahapatra of our village was contesting for Sarpanch. Venudhara Swain of Khasar village won the election. There was no relationship of my uncle Sukanta with Benudhar Swami. And our family is not in visiting Tal to the house of the Benudhar Swami. I do not know if Benudhar Swami was contesting for the post of for any party. My uncle was a dealer of a control commodity. It is a fact that my deceased uncle also
My uncle was
was controlling the BPL rice. I do not know if there was any allegation against my deceased uncle regarding misappropriation of BPL rice along with the sarpanch. The place of occurrence from our house within 1 kilometer distance. I distance.
about 15 houses intervened.
About 15 houses intervened in the place of occurrence and our house. There are 7 to 8 shops situated near the shop to which I was going. The house of Gauri Swami, rice seller and tailoring shop of Jotia Mahapatra, and house of house of Jyoti Ranjan Mahapatra and the house of Artatran Mahapatra are situated near the place of occurrence. The place of occurrence from the shop will be about 100 to 150 feet. The high school is situated at a distance of 800 meters from the place of occurrence. The Kosrada Gramya Bank is situated at a distance of 20 to 25 feet from the place of occurrence. The place of occurrence is on the road. I cannot say if the day of occurrence was the working day or holiday for the government office. I have read of cross to and past items Oraspur. Oraspur will be 10 kilometers from the place of occurrence. There is no outpost at Oraspur. From Oraspur near EPS is situated at a distance of 12 kilometers. I disclosed the occurrence before the doctor. I stayed at Oraspur hospital for about 20 minutes, and when the doctor declared my uncle to be dead, I went. I scribed the report at a distance of 300 to 400 meters from the PS after purchasing paper. Prior to 8 days of occurrence, I heard that my uncle is to be killed. The accused persons are of one family. Our family had got good relationship with the family of the accused persons prior to the occurrence. After hearing from me about hearing threatening, when I told my uncle, he did not give any importance. I did not ask the accused person after hearing from Hotto and Ghana as my uncle forbid me. I cannot say if my uncle has reported in the PS, but I have not reported about the threatening given by the accused persons. My uncle was selling kerosene in the market, and other control commodities are sold in the shop situated in our house. There was no permanent employee engaged in the shop of my uncle. The distance of the market from our village to where my uncle was going to sell kerosene will be 1/2 to 2 kilometer distance from our house. On Thursday at about 5 p.m.
Inquest over the dead body.
dead body was made. I cannot say as to what has been written in the inquest report as I have not stated. The police examined me at the time of submitting FIR and at the time of inquest, and thereafter I was examined by police. I have seen blood stain on the body of my uncle. I have not counted the injuries on the head of my uncle. Against it, there were 10 to 12 injuries on the head of my uncle. There was spot injury on the neck in the backside. I cannot say the measurement of injuries on the chest of my uncle. My uncle was laying on the ground at the time when I arrived at the spot. Soon after my arrival near the place of occurrence, Jabbu Sahu arrived. Jabbu Sahu never worked under my uncle. Except myself and Jabbu Sahu, there were no other persons present.
When Jogu arrived.
When Jabbu Sahu arrived near my uncle.
No. That is continuity. There was no other persons present when Jogu arrived near
Jabbu
me.
arrived. Yes, sir.
I did not.
I did not tell anything to Jabbu Sahu on his arrival. I am a private tutor without taking fees. I cannot say the total extent of our lands. It is a fact that my uncle was maintaining our family. It is not a fact that Jabbu Sahu, on arriving near my uncle, did not speak my uncle,
Did not ask my uncle.
did not ask my uncle, and that my uncle did not
tell that
the accused persons assaulted him. It is not a fact that I am deposing false. It is not a fact that I have not seen accused person assaulting my uncle. I know Kanu Mahabatra for the last 3 to 4 years. It is not a fact that I have not stated the name of Kanu Mahabatra before the police or in my FIR. It is not a fact that I have not mentioned the FIR or stated before the police regarding the prior threatening made to my uncle by the accused person. I know Madhav Kuntia since 85 to 86. I cannot say if Madhav Kuntia had got any inimical talk with any of our villagers. I cannot say what Madhav Kuntia was doing. I cannot say where Madhav Kuntia is staying at present. The accused Panchanan has got a grocery shop. Accused Hemanta has got a sweet stall. It is not a fact that I am deposing falsely at the instance of Sarpan. It is not a fact. There is no previous history.
We are asking a pertinent question.
Well,
We have also seen there are eyewitnesses to the occurrence.
well,
There is also dying declaration.
well,
And 15 injuries have been caused to the deceased.
well,
The evidence of the doctor is there. But in spite of all these things,
well,
in paragraph number 10,
well,
the trial court has mentioned that on perusal of the evidence on record, there is absolutely no evidence against Hemant Kumar Pradhan and Panchanan Pradhan. So this particular reason which he has given for acquitting those two persons without any other reason is not that he has assessed the evidence, found that the evidence is in respect those two appellants are discrepant, that is not acceptable. But the reason has been summed up in paragraph number 10 that there is absolutely no evidence against appellant Hemanta Pradhan and Panchanan Pradhan.
and Panchanan.
Panchanan Pradhan.
And Panchanan.
So once we find that on the basis of the eyewitnesses evidence or the evidence of the oral dying declaration made before PW5 coupled with the medical evidence, the evidence is consistent. Let us say, for example, the evidence is consistent against in respect or identical in respect of all the three accused persons, and they have used different sharp cutting weapons to assault the deceased. But the fact remains that two have been acquitted and you have not referred any appeal challenging the acquittal order. So now what would be the effect of if that the acquittal order remains unchallenged and we come to the finding that the acquitted accused persons and the present appellant stands on the similar footing? What would happen? You have not referred the appeal. So what is the way out? Let us say we have not we have just seen the evidence of, we have not gone the evidence of the in detail, of course, because he is not prepared. The question is that, let us say, acquittal orders of in respect of two have not been, but this court finds that they are similarly situated like the appellant.
May I say one thing, my lord?
The court, in spite of the fact that all the eyewitnesses and dying declaration coupled with the medical evidence is consistent, will acquit this appellant mainly on the ground or only on the ground that the similarly situated co-accused persons, two co-accused persons have been acquitted, or even though the court can find that yes, those acquittal order is not sustainable in the eye of law, but since that has not been challenged, in spite of that can convict or maintain the conviction of this appellant alone. This is the legal point. Court finds that we are giving an hypothetical. Court finds that two accused persons who were acquitted and the present appellant, they stand on the similar footing, basing on the eyewitnesses account, basing on the dying declaration, basing on the medical evidence. But that acquittal order has not been challenged and it has reached finality. Right? By the state, neither by the state nor by the informant. Or have you filed it?
CRL पे फाइल ହେଇଥିଲା କି ହେଇଛି ନାଇଁ
ନାହିଁ କରିବା ପୂର୍ବରୁ ଆଗେ ଭେରିଫାଏ କରିକି କୁହନ୍ତୁ। ନାହିଁ କରିବାଟା ତ ବଡ ଇଜି। ହଁ, you have to verify. So whether it has been challenged or not. Suppose it has not been challenged. Then the next question that whether in a such case the court can suo motu exercise its power, and when it finds that an illegal order of acquittal has been passed, can issue notice to them and give them an opportunity, and after hearing the other two accused persons who have been acquitted, can either confirm the acquittal order or set aside this. So different options are there. So in law, what is permissible, what is not permissible, you are to tell us. Right? We are giving you this thing. So you get prepared on this line. I think Mr. Mahapatra has also joined. Mr. Mahapatra.
No, we are not able to hear you.
Please unmute yourself.
Yes. No. There is some glitch from your side. Yes.
The proposition as you put that in not arise what I have gone through. Actually, what happened, I have just explained it. 5% were arranged actually. The 3% get their trial. So far, the other 2% those who were active, they were charged on section 120B, 300 to conspirator. Two other persons, they both trial is not known what happened their asylum. So the question which has been put by my laws is not synonymous with the case in hand.
No, if we see the charge in this case, the charge is framed against these three persons.
Out of 5 accused persons, 3 were acquitted, 2 were shown as absconder,
Right.
The other two those who are shown as absent, they are the assailants. So for the actual active persons are concerned, they are the conspirator. So that is the not the
Let's see the evidence.
Hemant,
Let us see the persons is accused number 3. He has been found guilty. So Hemanto and Panchanan are the persons who are facing trial.
120 bill my lord.
नहीं ये
चलिए आशीर्वाद पिक्चर को आशीर्वाद आसाला किन्यान को जने ट्रायल फेस करा So one thing I will propose to some people, my lord. My friend may collect their materials to what happened to those persons. So that the fact if they were acquitted,
you have prevented him to go through the file, Mr. Srivastava. The associate has not gone through the file. I thought that you have prevented him to go through the file.
no, that is not the fact. I
We expect that somebody is coming to court at least go to the file because how many years of practice?
henceforth I will instruct that they will assist the court by going through the file and that file. I am sorry.
We are repeatedly telling you how many years of practice? You know that you are and you are supposed to take an adjournment. Ask them if you are what is the getting the body of the right of the start and making the body of the right of the body. Challenge that the body taking the account of right or the mention right portion আমি जो हम तीन का accused identical evidence এখন কোশ্চিন করছে যদি যেটা বনাইଥାନ୍ତେ ସେତିକି ବନାଟା କଥା ନାହିଁ ଦି ଜଣ କାମେଶ୍ୱର
So far, the outcome has been what is the result of the case or is there an outcome claim that comes from the author instruction?
So Mahapatra, you have received the paper with the
Yes, sir.
Mr. Solution appeared to be and submitted that 5 accused, namely Kumar Pradhan, alias Hemu, Panchanan Pradhan, alias Vasant Kumar Pradhan, alias Sushant Kumar Pradhan, alias Sushant, and Suryakant alias Sahoo Hon'Ble were charge sheeted in this case under section 302, 109, 125, 34, and 2 of them at the time of charge sheet, only 2 of them were taken into custody. Panchanan Pradhan alias Vasu and Hemant Kumar Pradhan alias subsequently Vasant Kumar Pradhan alias Vasu was also taken into custody, was an absconder as per the charge sheet, was also taken into custody, and accordingly Hemu alias Hemant Kumar Pradhan, Panchu alias Panchanan Pradhan, and Basu alias Vasant Kumar Pradhan faced trial, and Hemu alias Hemant Kumar Pradhan and Panchu alias Panchanan Pradhan were acquitted of all the charges, and the appellant Basu alias Vasant Kumar Pradhan have been convicted under section 302 by 120B of the Indian Penal Code and sentenced to undergo RI for life. It is not known as to what happened to the absconding accused, namely Sukant Kumar alias and Suryakant alias Sahoo Hon'Ble, against whom the case has been prosecuted. Learning counsel for the state shall obtain instruction in that respect. The paperwork copy has already been received by the learning counsel for the appellant, also by the learning counsel for the state. Matter listed. Next of your Mr. Mahapatra, matter to next Tuesday. On 2nd of December 2025. 2nd of December 2025. Instruction shall be obtained. Any copy of the order will be Yes.
Another matter which I support to enter into appearance, that is 17 for this serial number. 17 of that also urgent to that date because I have not gone to that file.
All right. We are marking it. When the matter will be called, we'll add. Yes, next.
Item 13.
P.K. Mahanti, and the connected matter A.K. Chaudhary. So we have to engage somebody from the. Cannot keep this matter as such. If they are not appearing, it is up to them. Regular appeal would ask.
Yeah, Mr. Chaudhary stated that was intimated he was conveyed that his son will appear. That in of item 12.
CRA 71,
71.
son of Mr. Chaudhary.
So let him appear.
In case as I have intimated, he was just conveyed that his son will appear here in the
All right. Ask him to come after lunch. Okay, we are just passing it over. Next item.
Item 14.
Next Tuesday the
Oh, bhai.
Keeper my lord, because my father's illness my lord. Yesterday he killed my lord.
No. You have received the paper.
Yes, yes, I received my lord. Only one day I fell.
And you have been interested by the appellant.
Yes, sir.
After obtaining no objection from the appear in this.
Yes, Councillor died my
It's all right. So, and you have received the paperwork, so you are supposed to get prepared and.
Only my lord Tuesday first.
And the report has come from the IAC Chandipada police station that all are alive.
My lord, all are alive.
So now there is no problem. Council is ready and state council is ready. So we have to take up this matter. And why are you seeking for adjournment?
Because my
lord matters.
After launch, after launch, I will attend my father, my lord. That's why.
Next matter.
Item 15.
Rakesh Kumar Malik is the. You are there?
Item 15, my lord.
1-5.
Yes, my lord.
You to argue?
No, my lord. Actually, my lord, I have no instruction regarding the appellant is alive or dead.
No, appellant आमे आपको दे दो instruction. Janauchi Surendranath Sahu.
Yes, my lord.
Yeah, alive. Alive.
Where is the report? They will give you. Pass on.
8/8/25 report. It is ascertained that no one person is live at Pujari Put village in the name of Surendranath Sahu. An ordinary written report of Kishori Naik, Sarapam Chabus. And I thought it.
Delhi level maintaining very central. तारीख CORAM में देखिए. Surendranath Sahu alias Tuna ascertained that he is presently residing on rental basis in the house of Swanso, situated at Swanso, along with his wife for last 2 years, maintaining his livelihood as a daily laborer in Tiffin Hotel near SKT Hall, Jaipur, and his physical and mental condition is normal. So, alive, like there. The Learning Council for this is item number 15.
15.
The Learning Council for the state has produced the written instruction from the IIC, Jaipur Town Police Station, Koraput, dated 6/11/2025, which shows that the appellant is alive and his physical and mental condition is found to be normal, and he is residing with his family in Jaipur. The report is taken on record.
And along with another, with record is there, Mr. D. Panda is and the report for the K. Balaji Acharya. He's saying that the report is along with that. 9.
What is the
166 subsequent one.
Okay, Balaji. K. Balaji ର କିଛି ଆସିଥିଲା କି ଆଗରୁ?
ଆସିନି ତ। ଆସିଛି ଦେଖନ୍ତୁ ସେ ଗୋଟେ ଜାଗାରେ ଥିଲା ବୋଲି କହୁଛନ୍ତି।
ହେଲା ଦିଅନ୍ତୁ ଆପଣ ସେଇଟା। ଏଇଟା ତ ଆମେ କ୍ରିମିନାଲ ଆପିଲ 182ରେ ଲେଖିଦେଲୁ। ଏଇଟା ହଉଛି 182ର ରିପୋର୍ଟ। ବାକି ଆଉ ଗୋଟେ ତା ସାଙ୍ଗେ କନେକ୍ଟେଡ ମ୍ୟାଟର ଅଛି। ये बालाजी आचार्य कोठिकार लोक ତା ଦେହରେ ପୁଣି 2 ଜଣ ଅଛନ୍ତି। କେ ବାଲାଜୀ ଆଚାର୍ୟ ଆଉ ଗୋଟେ ହଉଛନ୍ତି କେ ମାଲେଶ୍ୱର ଆଚାର୍ୟ।
Right, probably that would have been. Yeah. It becomes for admission and yeah. It is considered that from the family and open criminality and criminality that refer criminality. Once it is everything. Exactly.
ଲେଖା ହେଇଛି ୱେଲବିଂ ଆଣିବେ ବୋଲି 24/10/2022 ଅର୍ଡର ଅଛି। ତାପରେ ଆପଣ ଟାଇମ ନେଇକି ଚାଲିଛନ୍ତି।
ନୋଟିସ୍ ହେଇଥିଲା appearing person ବୋଲି ତ ନୋଟିସ୍ ସର୍ଭ କରିଛି। 7/24
ଯଦି ଖାଲି ଆମର ଦରକାର ବଞ୍ଚି ଯଦି ତ ସେ ଯୋଉ ନୋଟିସ୍ ସର୍ଭ କଲେ କ୍ଲିକ୍ ଦେଲେନି ଆମକୁ କିଛି ଦେବେନି ନା ବଞ୍ଚିଛନ୍ତି କି ମାର ମାଲା। And in this case, Mr. Devasys Panda is appearing along with his IUC Mehta, Tonasi.
ସେ ନୋଟିସ୍ ସର୍ଭ କରିଛି ଆପଣଙ୍କ ଆଦେଶ ଅନୁସାରେ ମୁଁ ହାବିଲଦାର ଦେଇଥିବା ସମନ ଜୟପୁର ମୁକୁନ୍ଦ କେ ବାଲାଜୀ ଆଚାର୍ଯ୍ୟଙ୍କୁ ସମନ ଦେଇ ଏହାର କପି ସମନରେ ତାଙ୍କ ଦସ୍ତଖତ ନେଲି ଏବଂ କେ ମାଲେଶ୍ୱର ଆଚାର୍ଯ୍ୟ ସମନ ଦେଇ ଏହାର କପି ସମନରେ ଦସ୍ତଖତ କରି
କେବେ
8/12/22 ସର୍ଭ କରିଛି
7/11/24 ଗୋଟେ ଅର୍ଡର ଦିଏ
7/11/24
ଏଇଟା ତ ଏଇ ସମ୍ବନ୍ଧ
Mr. Panda submit that the applicant number 1 is bedridden and so on is available. So you can take up this matter. By the way, you obtain that instruction also in
my
that if he has job please. So that means the known person. You can just ascertain and ask him to give any written in writing that they are alive. And the health condition of they're residing with their family. That the notice has been served in 2022, 3 years apart,
and they are the local people. And the Surindranath staying outside Jaipur. He was on rent.
Like the CRA number. Anybody is appearing, Mr. Devasys Panda or his IUC Mehta there. So let's go. CRA number 166 of 2001 non appears for the appellants. The Land Council for the state submitted that it appears from his records that notice of this hearing of this criminal appeal was served on both the appellants, that is K. Balaji Acharya and K. Maleshwar Acharya on Kebe. Date खाली 2022 अपन कहले
8/12/22
8/12/2022 दी जन जाकर 8/12
personal service
by personal service. And however since 3 years have already passed, almost 3 years have passed, he will obtain a fresh report regarding the well-being by next week. Place this matter on 2nd of December 2025 है ना tweet कर देंगे CRA number 182 of 2001. So madam, you get prepared, either you argue or Mr. Malik argue, we do not know. We are keeping this matter 2nd December to prepare yourself. Okay. What about item number 16, Mr. Sarangi? Launch परिषद कार्य बोलते हैं Mr. Sarangi, get yourself prepared. Monchichi to? You
Not a one. Oh, item 16. That is 55. 55. Yes.
Single appellant. नहीं तो दी जन
नहीं second is जने मरिची जने
अच्छा किए मला मधु is dead.
Madhu Ayal is dead. Amara is
it has been awaited. Only appellant number 2 Amara Ayal.
deceased suffered a homicidal death, and the role of appellant Madha and appellant Nikhil stands clearly established. The consistent and reliable testimony of PW4 and 8, duly corroborated by medical evidence, proves beyond reasonable doubt that the first fatal assault was carried out in furtherance of their common intention, attracting the offense under section 302/34 IPC. Accordingly, we find no compelling reason to interfere with the well-reasoned findings recorded by the Second Additional Sessions Judge Cuttack in ST 313 of 1998 by order dated 5/10/2001. As a result, both the CRS stand dismissed. Before parting, this court places on record its sincere appreciation for the valuable assistance rendered by Mr. B.S. Raiguru, learned amicus curiae. The court acknowledges his diligent efforts and the able assistance extended in the effective adjudication of the present appeal. The court also records its appreciation for Mr. Parthasarathi Naik, learned additional government advocate, for his comprehensive submission and the clarity with which he presented the case.
I agree.
ପାସୱାର୍ଡଟା ଥିଲା
Mr. Sarangi.
ପାସୱାର୍ଡ ଥିଲା ଆଇଟମ 7 16 ନମ୍ବର ଆଇଟମଟା ଆଇଟମ 7 ପାସୱାର୍ଡ ଥିଲା ଜେଲର ସୁପରିଟେଣ୍ଡେଣ୍ଟ
ଓ ଆଚ୍ଛା, ହଁ ଠିକ ଅଛି।
ହଁ
Item 7.
କଣ ହେଲା ଏଇଟା?
ଆଇଟମ 7 ଥିଲା ବେଲ୍ ଯାଇନି ବଟ୍ ଜେଲର
ହଁ। His bail application was rejected on 13/10/2006.
Yes,
But about we wanted to know what is its present status. He is the jail superintendent.
madam.
Of which jail?
Sundargarh. District Judge Sundargarh.
Yes, what is your name?
Sir, namaskar. My name is Jivan Singh Munda, sir. Jivan Singh Munda.
Munda.
You are the jail superintendent.
Sir.
अच्छा, ये मंगुलु राउत बेली जने मुदाला जहाकु कन्विक्शन ହେଇଥିଲା 302 ଦଫାରେ ଏବଂ ଆଜୀବନ କାରାଦଣ୍ଡ ହେଇଥିଲା ସେ बेल एप्लिकेशन तार एई कोर्ट रे लास्ट टाइम रिजेक्ट ହେଇଥିଲା 2006 रे 13/10/2006 रे
सर
ତେଣୁ ତାପରେ ଆଉ ଏ କୋର୍ଟ ରେ ବେଲ ଉଠିନି ତ ସେ ଲୋକର ବର୍ତ୍ତମାନ କଣ ଇଏ କଣ ଷ୍ଟାଟସ୍ କଣ?
सर से कन्विक्शन पर प्रथम थर ପାଇଁ सर ପାରୋଲ ଛୁଟି ଯାଇଥିଲା ସାର୍ 27/6/2007 ଟୁ 26/6/2007 ତାପରେ ସାର୍ 27/7/2007 ରେ ସରେଣ୍ଡର କରିବା କଥା ସାର୍ ଜେଲ सर से सरेंडर करनी सर आमे नेसेसरी स्टेप नै सर एफआईआर देइछु राजगांगपुर पुलिस स्टेशन रे ट्रेस आउट हेनी सर सर अब्सकंड अछि
रिपोर्ट Jail को कौन report?
You often get that report. Yes, whatever he's telling, get it report so that we can take the necessary steps thereafter.
He says that FIR has been filed. When did they file the FIR?
So
what steps they have?
parallel ଜିନିଷ report ରେ ଯୋଉ କୋଉଠି ଦିଆ ହେଲା ଆମେ କହିଲେ ଆପଣ status ମାନିବୁ ସେ case ର କଣ ହେଲା ସେ ଲୋକର whereabouts ହଁ
You had sought it from the IIC.
Yes, I am
No, there is no
to the
point
IIC,
because
I'm not
he's there.
in the jail. So
ଦେଖନ୍ତୁ none appears for the appellant. This criminal appeal is of the year 2005 and the bail application the appellant was rejected as per order dated 13/10/2006. To know the status of the appellant, we asked the Learning Council for the state to ensure the appearance of the jail superintendent, district jail Sundargarh, virtual mode. And accordingly, Mr. Jivan Singh Munda, superintendent, district jail Sundargarh appeared through virtual mode, and he submitted that the appellant has gone on parole in the year केबे जाइथिले
So 2007 sir, 26/6/2007
on 26/6/2007 for a period of
1 month.
for a
30
period
days.
of 1 month, but he didn't surrender. So and accordingly, the first information report was lodged in Rajgangpur police station.
Sir.
Rajgangpur police station, and since then the appellant has not yet been apprehended. Let a report to that effect be filed by the jail superintendent with the report the stated to have been lost in connection with the absconding of the appellant before the Rajgangpur police station. Matter will be listed day after tomorrow. We can just send it that report. ଆପଣ ଏ ମ୍ୟାଟରଟାକୁ ଆମେ ଡେ ଆଫ୍ଟର ଟୁମୋରୋ ରଖୁଛୁ ଅର୍ଥାତ୍ 27 ତାରିଖ ଦିନ ଆପଣ ଗୋଟେ ରିପୋର୍ଟ ଦେଇଦେବେ ଇମେଲରେ ଆପଣ ପଠେଇ ଦିଅନ୍ତୁ ସରକାରୀ ଓକିଲଙ୍କ ପାଖକୁ ହେଲା ତା ଦେହରେ ଯାହା ହେଇଛି ଯୋଉ କହୁଛନ୍ତି ଡିଟେଲ ଦେଇକିନି ଆପଣ ଦେବେ ଆଉ ଇନକ୍ଲୁଡିଂ ସେ ଯୋଉ FIR ଯୋଉ ଦିଆ ହେଇଛି ତାର ମଧ୍ୟ ଡିଟେଲ୍ସ ଟା ଦେଇଦେବେ ଦେନ୍ we'll take the follow up action ହେଲା
sir.
But in your way you can go for that.
Yes,
IAC को कौन तो राजगांगपुर पुलिस स्टेशन कारण आपण जानिले बर्तमान से बाहर कोनो आपण भी रिपोर्ट मगैथिले बोधे बाहर माने IAC मगैथिले IAC किसी देई ना रिप्लाई ताकू IAC संगे ये कहि दियंतु जे एई टाइप रो होइछि माने नॉर्मल भी माने पेले जाई कि नहीं नो से पडे नुची थिबो कि कोन हेतु कहिकिन से रिपोर्ट मध्ये जदि हो आनो हला we are listing it day after tomorrow. Personal appearance of so and so is dispensed with. Next. आपण जाई परंती
Sir.
Item 16.
Mr. Sarangi, you have
one appellant number 1 is dead. Only interspector 2 is
no, you have been engaged as amicus too?
no, it's me. Original.
You have filed the branch. So, as it appears on 19/8/2025, we have passed the order that the appeal abated so far as appellant number 1, Madhu Ayal is concerned. So now it is only Samra Ayal.
Informant is Raghunath Hanta. His brother is the deceased. Hasiram Hanta.
It come to the FIR.
Page 24. Date of occurrence is 30th/6/99. FIR was on 3/7/19. Page 24. May I read it?
Yes, please.
ମୁଁ ରଘୁନାଥ ହନ୍ତାଲ ପିତା ଜୟରାମ ହନ୍ତାଲ ଗ୍ରାମ ଆମପଡ଼ା ଥାନା
PW
is PW3 ଜଣେ ରିପୋର୍ଟ ହେଇକି ଯେ ମୋ ସାନ ଭାଇ ଶ୍ରୀ ଘାସିରାମ ହନ୍ତାଲ ବୟସ 35 ହେବ ଗତ ବୁଧବାର ଦିନ ଦ୍ୟାଟ୍ ଇଜ 30/6/69 ଚାଷ କାମ ସାରି ଦିନ ପ୍ରାୟ 10 ଘଣ୍ଟା ବେଳେ କୁମ୍ଭାରପୁଟକୁ ବଜାର ସଉଦା ପାଇଁ ବାହାରିଲା।
Hasiram is the deceased.
ସେଦିନ ରାତିରେ କେଉଁଠି
ଚାଷ କାମ ସାରି
ଚାଲିଗଲା। ସେଦିନ ରାତିରେ କେଉଁଠି ରହିଯାଇଥିବ ଭାବି ଖୋଜି ନଥିଲୁ। ଗଲା କାଲି
ଶୋଇଯାଇଥିବଟାକୁ ସେ ସହିଯାଇଥିବ ତାଙ୍କ ଭାଷାରେ
ସହିଯାଇଥିବ ବୋଲି ଭାବିଲୁ। ଖୋଜି ନଥିଲୁ। ଗଲା କାଲି ଖୋଜିଲା ବେଳେ ଆମ ଗାଁର ଶ୍ରୀ ପ୍ରଫୁଲ୍ଲ ଆୟାଲ PW4 ସଞ୍ଜ ବେଳେ ମତେ କହିଲା ଭାଇକୁ କିସ ପାଇଁ ଖୋଜୁଛୁ। ଗଲା ବୁଧବାର ଦିନ ରାତି 9:30 ସମୟରେ ତାକୁ ଆମ ସାହିର ମଧୁ ଆୟାଲ ଓ ସମରା ଆୟାଲ ଟାଙ୍ଗିଆରେ ହାଣି ମାରିଦେଲେ। ମତେ ଜବରଦସ୍ତି କରି ଡାକିଲେ। ଆମେ ସମସ୍ତେ ମିଶି ଡାକିନେଲେ। ଆମେ ସମସ୍ତେ ମିଶି ତା ମଢକୁ ବହି ନେଇ ତିଳ କପୁଳି ପାଖ ଗାଢରେ ପୋତି ଦେଇଅଛୁ ବୋଲି କହିଲା। ତା କଥା ଶୁଣି ଆଜି ସକାଳେ ଗାଁର ମେମ୍ବର ଶ୍ୟାମସୁନ୍ଦର ହନ୍ତାଳ PW5 ଓ ଭଗବାନ ହନ୍ତାଳ ଶ୍ରୀ ଚଣ୍ଡାଳ ମୁଦୁଲି PW7 ଧନୁଞ୍ଜୟ ସିସା PW6 କମଳ ହନ୍ତାଳ ମଙ୍ଗଳା ମୁଦୁଲି they are not been examined ଉଦ୍ଦେଶ୍ୟ ଘେରା ଓ ଅନ୍ୟମାନେ ଥାଇ ପଞ୍ଚାୟତ କଲୁ। ଉକ୍ତ ପଞ୍ଚାୟତରେ ଶ୍ରୀ ପ୍ରଫୁଲ୍ଲ ଆୟାଲ ଉକ୍ତ ଘଟଣା ବିଷୟ କହିବାରୁ ଶ୍ରୀ ମଧୁ ଆୟାଲ ଶ୍ରୀ ସମର ଆୟାଲ ପଞ୍ଚାୟତରେ ଦୋଷ ମାନି କହିଲେ ଯେ ଘାସିରାମ ହନ୍ତାଳକୁ ଆମକୁ ଚାପଡ଼ା ମାରିବାରୁ ଆମେ ରିସା ହୋଇ ତାକୁ ଖେଦି ନେଇ ଟାଙ୍ଗିଆରେ ମାରିଦେଲୁ। ସେ ମରିଯିବାର ଭୟ ହୋଇ ଆମର ବଡ଼ବାପା ପୁଅ ସାନ ଭାଇ ଶ୍ରୀ ପ୍ରଫୁଲ୍ଲ ଆୟାଲକୁ ଜବରଦସ୍ତ ଘରୁ ଉଠେଇ ଆଣିଲୁ। 3 ଜଣ ମିଶି ଶ୍ରୀ ଘାସିରାମ ହନ୍ତାଳର ମଢକୁ ତଳ କୁପୁଲି ଗାଡରେ ପୋତି ବାନ୍ଧି ଦେଇଛୁ ବୋଲି କହିଲା। ପ୍ରଫୁଲ୍ଲ ଆୟାଲ ମଢ ପକ୍କା ଜାଗାକୁ ନେଇ ଆମକୁ ଦେଖାଇ ଦେଲା। ଘାସିରାମ ହନ୍ତାଳ ମଢ ମାଟି ଭିତରେ ରହିଛି। Thereafter, HOD magistrate was called. He has also been examined.
Disinterred.
And dead body was recovered. It was shown by PW4 and the place of at his instance it was recovered. Now the informant has shown posted. PW3.
PW1K. I do not know anything about the case. PW2. That's which one or to the dead body.
Constable.
The constable. Numbers of using informant.
I know the accused persons and the accused. About 2 years back in a day, Prafula Ayal came and told me about the murder of Ghasiram Hantal by accused Samarayal by means of a tangi. PW 3 37 page.
PW
4. Only
PW
go to the page evidence.
told me that about the murder of Ghasiram.
Murder of Ghasiram Hantal by accused Samarayal by means of a tangi. I immediately went and informed the villagers. We called a panchayat in presence of all the villagers. Accused Samara was called, but he did not came nor attended the meeting. Thereafter, he was declared hostile. It is not a fact that I have mentioned in my affair and stated before the IO that Samara Hial confessed in the panchayat to have killed by an axe to Ghasiram Hantal. Sam Sundap Hantal, the village member who wrote the affair on my instruction and read over the contents thereof to me and took my LTI thereof. It is not a fact that there was compromise effected in the village for which I reside from my earlier statement. I do not know the contents of the affair. It is not a fact that Prafulla came and told me that accused Samara had killed Ghasiram Hantal to death by means of an axe. What is stated in chief again denied in proceedings. The house of Prafulla is about 3 kilometers away from my house. Myself and Prafulla used one bathing ghat Delhi at the time of our birth.
Number
Next page, 38. I know the accused persons and the deceased. At about 10 p.m. in a Wednesday about 2 years back, accused Samara called me from my house and told to have killed Ghasiram Hantal by means of an axe and called me to the place of murder, to which I refused. Then suggestions have been given. Cross-examination, he says, I have not seen the occurrence nor the dead body since I have not come out of my house. Next page. My house would be at a furlong distance from the house of the informant. The house of Budura Ayal is adjacent to my house. Budura is staying with his family members in the said house. It is not a fact that Samara came and called me from my house and told to have killed the deceased. Whatever is stated in the chief, half stated, half did not state, declared hostile, therefore again contradicted the same person.
No, in the chief he has stated about that Samara means appellant number 2 came to his house and told him
to have killed the deceased.
He has killed and Dakinala spot
and called me to the place.
To which I refused. But the affair and the consistent story is he was informed, then he went with them and buried the dead body. And he is the person who led to discovery of the dead body.
I have not seen the author or the dead body since I am from outside people in my house for long time.
Next is Pidula 5, one line, scriber of the affair. He denies and states that I wrote this affair in the police station at the instruction of the vice.
PW 6.
PW 6, 5.
5, 6, so see, villagers का पता है.
PW 6, Dhananjaya Sisa. I know the accused persons and the deceased. About 2 years back, there was a panchayat held in our village in presence of the villagers. Accused Samarayal came and confessed before the villagers who had Ghasiram Hantal to death by means of an axe. Accused Madhu told before the panchayat that accused Samara killed Ghasiram Hantal before the villagers. Accused Samara has not attended the panchayat. I have not stated before the IO that accused Samara came and confessed before the panchayat to have killed Ghasiram Hantal. Now, Samara, then cross again deny.
Next
is
number
7.
villager.
I know the accused persons and deceased. There was a panchayat in our village. I was present in that said panchayat. Accused Madhu Ayal came and confessed before the panchayat that accused Samara murdered Ghasiram Hantal by means of an axe. He says Madhu Ayal that appellant number 1 confessed that appellant number 2 has killed. It is not the fact that there was no panchayati nor Madhu gave any confession in that said panchayat. Some says Samara made the confession, others says
Next, 7.
7.
8.
The deceased is my husband. Riddle 8. My brother Prafulla came and told me that accused Samara had killed my husband by means of an axe. I went and saw the dead body of my husband, which was covered under the earth near the river. It is not a fact that I did not state to the IO that Prafulla came and told me that accused Samara killed my husband by means of an axe and had covered the dead body near a river under the earth. It is not a fact that I deposed false. For evidence is hearsay.
Prafulla kiye?
PW4.
PW4 আছে। PW4 himself has not stated that he
informed anybody or asked in the chief he states that he only informed.
Declare hostile, but thereafter in the cross PW4 declare hostile. But cross examination, how is it?
When entire statement has been confronted, he has stated that it is not a fact. And in the chief examination, he has stated that it was Samara who called him and told him to have killed Swanson. But he said that my house would be so-and-so, the house of so-and-so, Dura is staying in his family, it's not a fact. So
look where remove and cover the dead body with soil.
Cross-examination, last part. It is not a fact that Samara came and called from my house and told to have killed the deceased. So again contradicts that chief in para 7.
No, he said here the suggestion he has denied. It is not a fact that Samara came and called me. So this suggestion he has defense.
He accepted that. It is not a fact that Samara came and called me from my house. That Samara has not.
164
Just a minute.
Shift go in. Continue.
Samara came and to his house and told
to have killed the deceased.
Okay.
It is not a fact.
It is not a fact.
That Samara came. What is stated in chief that Samara came and confessed. Here he again says it is not a fact that Samara came and. So it's not negative. It's only negative.
It's not a fact.
It is a fact that if you would have said, then it corroborates the chief.
It is not a fact that Samara did not come to and called him to have
এটা negative হলে সেটা it's again
suggestion টা जो লেখা হয়েছে
it again goes contrary to the chief.
It's not a fact that Samara came and omit कर दीजिए did not কারণ suggestion दिया है but এটা ডিফেন্স নিশ্চয় সাজেশন দিয়েছে দেখো তম ঘরକୁ Samara আসিন
your lordship has also seen other witnesses what they say in the chief.
No, that is in the context of other witnesses, it's all right. Who actually came and confessed because
that is also not some says
village meeting रे ଆପଣଙ୍କର ଯୋଉ contradictory but ଏଇଟା ହଉଛି କଣ PW4 ର ଘରକୁ ଯାଇକି ଯୋଉ confession କରିବା କଥା ସେଟା
ପଞ୍ଚାୟତ
ଗୋଟେ ହଉଛି ପଞ୍ଚାୟତରେ ଗୋଟେ ହଉଛି ୟା ଘରେ 4 ନମ୍ବର
that automated ଗୋଟେ ପେଜ ପଢି ଦଉଛୁ ସବୁ
ଆମର ଯାଇଥିଲା କୁଆଡେ କୋଉ ଉପରେ ଯାଇଥିଲା 7 ପରେ 8 ଆସିଲା
wife
9
brother my brother Prafulla came and told me that accused Samara had killed my husband by means of an axe. So here say this is the wife. Then 9. It also not relevant is the
wearing
apparel of the deceased.
10.
After the occurrence, we held a meeting in the village. Accused Samara confessed in the same meeting to have killed the deceased. Cross-examination. Podu Naik, Dhanu Sisa, Raghunath Hantal, Prafula Ayal were present in that same meeting. The accused was originally reluctant, but when the villagers insisted for his confession, he admitted to have killed the deceased. Exactly what I am pointing out. Once it is read, then the extrajudicial confession character goes. Everything goes. Your Lordship knows the moment it seems what has been interpreted, the word appears, means seems. The moment it seems it's not voluntary, then it has to be thrown out.
What is the next phase cross-examination on this?
Peculiarly, Milords, this witness was examined twice. I am otherwise known as Dhanurjaya Sisa, son of Sannyas Sisa. Since my father was village Naik and I am still continuing at the same post, I am known as Dhanurjaya Naik. I have deposed twice in court as PW 6 and 10, once as Dhanurjaya Naik and second time as Dhanurjaya Sisa. But I am the same man bearing the name of Dhanurjaya Sisa alias Naik. I have not seen the accused Samara speaking before any panchayat and making a confession of his guilt.
ସେଇ ଲୋକଟା ବି 6 ନମ୍ବର ସାକ୍ଷୀ ହିସାବରେ
ଆଜ୍ଞା।
ଦେଖୁଛନ୍ତି।
ଆଜ୍ଞା।
ଛୁଟି ସେ କଣ ଡକ୍ଟର ସେମ୍ ତ କରିଛି ଆଲାଉ କେମିତି କଲେ?
And court says this contradiction should not be accepted because we should have cross-examined what he has stated in PW6 as PW10.
Dhananjaya Sisa
is the same person, right?
is the son of Sariya Sisa. Sonia Sisa.
ନିଜେ କହୁଛି ମୁଁ 5-6 ନମ୍ବର ସାକ୍ଷୀ ହିସାବରେ ଡିପୋଜିସନ ଦେଇଛି ମୁଁ ଦିଥର ଏକ୍ସାମିନ ହେଇସାରିଲିଣି ଗୋଟେ ହଉଛି 6 ନମ୍ବର ସାକ୍ଷୀ ହିସାବରେ ଗୋଟେ 10 ନମ୍ବର ସାକ୍ଷୀ ହିସାବରେ and signature is also same ଧନୁଜୟ ସିସା ଆଉ ବାପା ନା କଣ ଦେଖୁଛି ବାପା ନା
ସେଟା ସିଏ କହିଲେ ତା ବାପା ନାୟକ ଥିଲା ତାପରେ ସିଏ ଗାଁ ନାୟକ ହେଲା ପରେ ନାୟକ ବୋଲି ବି ତାଙ୍କ ଟାଇଟଲ ଅଛି ସିସା ବୋଲି ବି ଅଛି so he was examined as Dhanujaya Sisa and as Dhanujaya Naik because his father was the Naik and Naik means that Gramarakhi.
In the charge sheet witness, he is Dhananjaya Naik and 7 is Dhananjaya Sisa.
Yeah, he is the same person.
Deposed twice in the court.
ये डिफेंस ये रिकॉल करिक से करा है जे एटी चार्ज शीट देला बेलकू चार्ज शीट विटनेस हिसाब रे 6 और 7 रे से अछि
that has been clarified subsequently.
Same person.
When defense found out that the same person was deposed. If is accepted, then everything goes. And so far as character of PW4 is concerned, in the FIR it is stated forcibly he went there and helped them. He led to discovery, which he is denied. But then he goes to the stage of an accomplice. His version also is no way helpful to the prosecution.
What about the rest witnesses?
Rest witnesses, same. Again, 8, 9, nothing. Wiring up to 10. You'll also have seen 11 is not over. 12 is 13 is the executive magistrate. Cross-examination, he says one Profulanta led me, police and doctor, to the place where the dead body was disinterred. Then the doctor is PW14.
Profulo is not an accused before us.
No, Profulo is PW4. Who stated that forcibly I went there, but in the chief he result from that he was declared hostile. Then
so it is not at the instance of
accused persons.
Accused persons, because this witness has not stated that these two accused persons were present when the body was disinterred.
Yes. And so far as the version of Profulo that he told me, Samara told me that he has killed, that also goes because he becomes an goes to the place of an accomplice, if not an co-accused. That's something in between is an accomplice. A sympathizer, a person who, though helped in the crime, may not be effectively called an accused. So if he is an accomplice, his evidence goes. And if this version of PW6,
let us see that what the police has stated about this.
Yes.
Because next witness is a postmortem
Doctor.
Cause of death was due to swan infection.
Yes.
And I collected sample blood to find the police story. This type of injury also is possible by diarrhea injury effect. Now this is the IO, PW15.
15. Page 15.
Please place it.
On 3/7/99, I was OIC Mudilipada PS. On that day, while camping at village Modiguda outpost, I received the FIR from Raghunathan. I perused the FIR and sent it to the police station for registration of the case. The case was registered under section 302/201/34 IPC. Under PS case number 30/99, I took up investigation of the case. During my investigation, I examined the complainant and other witnesses, visited the spot, that is burial place, and seized the dead body by disentering from the ground, held the inquest of the dead body in presence of the witnesses, prepared the inquest report marked as Exhibit 4, and Exhibit 4/2 is my signature. Sent the dead body to hospital for postmortem examination by issuing the dead body challan marked as Exhibit 1 and Exhibit 1/2 is
This
my
IO
signature.
has not stated that at anybody's instance this dead body was dissented. He simply stated, I went there, examined, and went to the burial place, see the dead body. Not stating that it was at the instance of that Profullo, which has been deposed to by that executive magistrate or the BDO. This evidence as if he himself would.
Appears to be a very novice man and has not taken the investigation in the manner it has been taken. Does not know ABC of investigation.
Usually in that locality, they don't do anything.
No.
After the incident, most of the time,
No.
they go to the village,
No.
sit in there.
No.
Most of the cases, you'll also
Don't
will find.
underestimate. No. There are very good investigating officers.
Even if in the
This particular fellow doesn't.
The usual practice is they call the villagers, ask them, give the accused extrajudicial confession,
See what happens.
leading to discovery. Then in the village they settle. All the witnesses turn hostile. That is the.
But what we, from the evidence, what we find that the executive magistrate version that at the instance of Mr. PW4, it was dissented and I accompanied there with the IO. That IO means obviously PW15.
Is the only IO.
But PW15 himself has not stated that it was this Topful or PW4
led to.
So that is there already. Yes, next. Read it out, Mr.
Postmortem exam by issuing the dead body challan, Exhibit 1, 1/2 is my signature. Seized the blood-stained earth and sample earth from the spot, that is on the Gram Panchayat road, on 4/7/99 and prepared the scissor list in presence of witnesses. This is the scissor list marked as Exhibit 8 and Exhibit 8/1 is my signature. Seized the check lungi, blood-stained, and one powder on 6/7/99 from accused Samarayal in presence of the witnesses and prepared the scissor list marked Exhibit 9 and 9/1 is my signature. On 4/7/99 seized a piece of wood measuring 4 feet into 6 feet, 4 feet 6 inches from the place of burial of the dead body in presence of the witnesses and prepared the scissor list marked as Exhibit 10 and 10/1 is my signature. On 6/7/99 seized one blood-stained tangia, iron portion bracketed, and one check lungi blood-stained from accused Madhu Ayal in presence of the witnesses and prepared the scissor list marked at Exhibit 11 and Exhibit 11/11/1 in my signature. Received the postmortem report and made a requisition for collection of nail clippings of the accused. This is the requisition marked as Exhibit 6/2. Made a query to the doctor who conducted postmortem examination by producing the weapon of offense and obtained the query report. This is the query requisition marked Exhibit 7/2 and Exhibit 7/3 is my signature. forwarded the blood stain exhibits to the chemical examiner through the STJ Malkangiri. This is the forwarding letter 26 marked at exhibit 12 and obtained the CE report 26 marked at exhibit 13 and this is the ballistic report marked as exhibit 14. The dead body was disinterred in presence of the magistrate. This is the 164 statement of witnesses Prafulla Ayal recorded by the magistrate marked as exhibit 15 and on completion of investigation I submitted charge sheet. It is a fact. It has been mentioned in the affair that Samara Ayal made confession before the Panchayat to have killed Ghasira Mantal by means of an axe, and this affair was written by Samsundar Hantal, and the affair do not show that any compromise was effected in the village. Cross-examination. PW6, Dhanurja Sisa has stated before me that accused Madhu and Samara stated before the Panchayat to have killed Ghasira Mantal. I verified the statement recorded under section 164 CRPC of Prafulla Ayal before submission of charge sheet. The so-called LTI taken in Exhibit 15 has not been attested. It is not a fact that Prafulla Ayal was not produced before the magistrate after recording his 164 statement. It is not a fact that no incriminating articles were seized from the position of the accused persons. It is not a fact that the investigation is performed through.
Even this inquest report, which is Exhibit 4, there also that is nothing that it was presented at the instance of either any of the appellant or this PW4 as deposed to by this executive magistrate PW30. It was simply written that Mutapaku Puspatra Mati Toru the Kodi Dekivare Mutapaku Swanso Pahala. It's in even if this PW4 PW4 ଗୋଟେ LTI ଦେଇଛି ତାର LTI ରେ ତା ନାଁ ବି ସେଠି ଲେଖା ହେଇନି ଯେ ଏଇଟା ହଉଛି ଆର LTI ବୋଲି ମାନେ ପ୍ରଫୁଲ୍ଲ ଆୟାଲ ର କୌଣସି ଗୋଟେ LTI ଅଛି ସଦା ସିସା ଆଉ ଗୋଟେ LTI ଅଛି କଣ ଝିଅ ପୁରା ଆଉ ଗୋଟେ LTI ଅଛି ଧନଞ୍ଜୟ ସିସା ତିନିଟା LTI ଅଛି ଆଉ ଏଇ ଯୋଉ ପ୍ରଫୁଲ୍ଲ ହିଆଲ ଯିଏକି PW4 ଯାହାର ଇନଷ୍ଟାନ୍ସ ରେ ଏକ୍ଜିକ୍ୟୁଟିଭ ମାଜିଷ୍ଟ୍ରେଟ କହୁଛନ୍ତି ଯେ ଡେଡ୍ ବଡି ଟା ଡିସେଣ୍ଟର୍ଡ ହେଇଛି ଦ୍ୟାଟ୍ ଇଜ ନଟ୍ ଦେୟାର କିମ୍ବା କୌଣସି କଲମରେ ବି ଲେଖା ନାହିଁ ଆ ଦେହରେ ଯେ apart from the we thought that inadvertently he might have missed it that IO but ଏଥିରେ ମଧ୍ୟ କିଛି ନାହିଁ
ତାକୁ ପଦାକୁ ବାହାର ଆମେ ସାକ୍ଷୀ ମାନଙ୍କ ସାମ୍ନାରେ ଓଲଟ ପାଲଟ ତାପରେ ଦେହ ଥିଲେ
ନାଇଁ ଇଏ ନେଇ ଦେଖେଇଦେଲା
ଆମର ଇମ୍ପୋର୍ଟାଣ୍ଟ ସେଟା
ଇମ୍ପୋର୍ଟାନ୍ସ ହଉଛି PW4 ଦେଖେଇଦେଲା ଏବଂ ବା ଏମାନେ ଆପେଲାଣ୍ଟ ମାନଙ୍କର ପ୍ରେଜେନ୍ସ ଯୋଉ ଦି ଜଣ ଆପେଲାଣ୍ଟ ଏଇଟା ଟୋଟାଲ ମାନେ କିଛି ନାହିଁ ତେଣୁ ଇଟ୍ କ୍ୟାନଟ୍ ବି ସେଡ୍ ଏବଂ ଆପଣଙ୍କର ଆଇଓ ବି ସେ କଥା କହୁ ଯେ କାହା ଇନଷ୍ଟାନ୍ସ ରେ ତେଣୁ in that way this IO's version and the executive magistrate version is not matching with each other karan apanakar executive magistrate is also a witness to the inquest his signature is there exhibit 4/1 he has proved his signature kintu jadio se kahuchi je Prafulla Hanta led me police and doctor to the place from where the dead body was disinterred but IO's evidence is silent, number one. Number two, you're that very document, that exhibit 4, nowhere it indicates that at the instance of this man, PW4, it was disinterred. କାରଣ ordinarily ତାର ବି signature expect କରାହଉଥିଲା ନା ତ IO କହିଛି ନା ସେ document ରେ କିଛି ଉଲ୍ଲେଖ ଅଛି ନା PW4 ର signature ସରି LTI ଅଛି ତେଣୁ ସେଇଟା ହଉଛି ବାକି ଆପଣଙ୍କର କେସ୍ ବେସ୍ କଣ ଆସିବ ଆସିଲେ ଏକ୍ସଟ୍ରା ଜୁଡିସିଆଲ କନଫେସନ ଯଦି ଗାଁ ଯୋଉ ଲୋକଙ୍କ ପାଖରେ ଏଭିଡେନ୍ସ ଆସିଲାଣି ତାକୁ ସିଏ ପ୍ରଥମେ ମନା କରୁଥିଲା ତାକୁ କଣ ଜବରଦସ୍ତି କରେ ନା କଣ
ଇନସିଷ୍ଟ
ହଁ ଏଇଟା କଲାଠୁ ଆଉ ବାକି ଗୋଟେ ଯୋଉ ଅଛି ତା ଘର ପାଖରେ ଯାଇ କହିଲା ସେଟା ହଉଛି ଗୋଟେ ୱିଟନେସ୍ କି ଗୋଟେ କହୁଛି
ସେମ୍ PW4
ହଁ ସେ PW4
that statement is page 45. The accused was originally reluctant, but when the villagers insisted for his confession, he admitted to have killed the
no PW4 ता या घरे जाई ये समरा अपलाइन नंबर 3
So the only witness is PW4. At about 10 p.m. in the Wednesday, about 2 years back, accused Samara called me from my house and told to have killed Ghasiram Hantan by means of an axe and called me to the place of murder, to which I refused.
What is the closeness between this apparent Samara and Dr. Ayal? While you go there and make confession, you have to bring something on record that it must inspire confidence and extrajudicial confession ro jo principle rohuchi with a weak piece of evidence rohuchi how it should be it should pass the test it takes raw evidence which hostile legalani it takes raw evidence how how the baki jodi kichi nahi how can you question a conviction on this type of event?
So the nature of evidence what was expected in this case was the last century, which is not there. Only extrajudicial confession, which is distorted. Third thing leading to panchayat. So though the evidence with regard to a panchayat having called is consistent by everyone, but there is prevaricating with regard to the manner in which it was confessed either Samara or by another.
ଅଛି ଯେ ତାକୁ ପ୍ରଥମେ ମନା କରୁଥିଲେ insist କଲେ ଏମିତି ଗଲା ସେଇଟା ଗୋଟେ ରହିଛି
So the star witness PW4, who was also examined under 164, has not been confronted. 164 ଟାକୁ confront କଲେ ନାହିଁ କିଛି ବି ଆଣିଲେନି ଆଉ IO is still dubious. Leading to discovery achi, but he did not. So what prevented him not to bring it on record? Witness na hostile ହେଇଯିବ IO to hostile no. So what prevented him not to bring it in the manner he has developed as in the charge sheet? But he did not even bring that. ଆଉ matching କଣ ଅଛି blood SFSL report wearing apparel.
Northern Tangia has been seized.
କଣ ଅଛି SFSL report?
That is the page 50. Page 56 is the first report. It is a forwarding report.
That is forward. Human nursing, यार Tangia no opinion.
ସେ ଯୋଉ ଇଏଟା ଅଛି ସେଟା ହଉଛି ପୋଷ୍ଟମର୍ଟମ ହେଲା ପରେ ଆର ଖାଲି ଗୋଟେ ଟାଙ୍ଗିଆଟା ପ୍ରଡ୍ୟୁସ କରିଥିଲା ଆକ୍ୟୁଜ ମଧୁ ଆଇଆର ଲେଖା ହେଇଛି ଏଠି ଏଇ ଯୋଉ କଲମରେ ଟାଙ୍ଗିଆ on production by accused Madhu Iyer. How did you link it with
these figures were made on 6/7/99.
Then already Tangia no opinion asla ଆଉ ସେ ଟାଙ୍ଗିଆ ସିଜର ଯୋଉ ହେଇଛି ଲେଖିଛନ୍ତି ଏଟା କିଏ କହିଛି
that was seized on 6/7/99.
ଏବେ
6/7/99.
6/7/99 yes seized ହେଲା Tangia
from both accused persons different objects from
सारी साथ रे
एक लुंगी broad stand And one Howdah.
Howdah. Howdah जो
Howdah is
One-
paid.
हाँ Howdah.
That is paid.
Yes.
All
From
six
accused
are
Samaraya.
From Samaraya. In presence of the
Exhibit 9.
On charge has also seized a piece of wooden measuring 4 feet 6 inches from the place of burial of the dead body in presence of the witness and prepared to
167
accused ର ଯୋଉ ଲୁଙ୍ଗି ଆଉ ଇଏ ଅଛି ଦିଟା D ଆଉ E ମାର୍କ ହେଇଛି ଗୋଟେ ହଉଛି from accused ମଧୁ ଆୟର ଗୋଟେ ଆଉ ଗୋଟେ ହଉଛି from accused ସମରାମ ଗୋଟେ ମାର୍କ ହେଇଛି D ଆଉ ଗୋଟେ ମାର୍କ ହେଇଛି E ଫରୱାର୍ଡିଂ ରିପୋର୍ଟ ଦେଖ 56 ପେଜ ରେ ହେଲା ଏବଂ ତାର D ଆଉ E ର ଇଏ ଆସୁଛି no blood ମାନେ ଯୋଉ पोस्टमार्टम रिपोर्ट ଟା ମାର୍କ ହେଇଛି exhibit 13 ସେଟା no blood ଟାଙ୍ଗିଆରେ blood ଅଛି origin ନାହିଁ no opinion ଆଉ ବାକି nail clippings ବି ନାହିଁ no blood ଦେଖ two appellants Madhu Ayal and Samara Ayal who have preferred this criminal appeal face trial in the court of London Additional Session Judge Malkangiri in Sessions case number 19 of 2000 for offences punishable under section 302 by 34 and 201 by 34 of the Indian Penal Code on the accusation that on 30th June 1999 at about 9:30 p.m. at Ambapada village under Mudulipada police station in the district of Malkangiri, they intentionally committed murder of Hasiram Hantal, bracket like them here and after, the deceased in furtherance of their common intention and knowing or having reason to believe that the offense of murder has been committed, caused certain evidence connected with the said murder to disappear by burying the dead body with intention to screen themselves from legal punishment in furtherance of their common intention. Stop. The London trial court provide judgment and order dated 18th February 2002 found the appellants guilty under section 302-201 by 34 of the Indian Penal Code and sentenced each of them to undergo imprisonment for life. However, no separate sentence was passed under section 201 of the Indian Penal Code. Stop. Next part. The prosecution case, as per the first information report lodged by PW3 Raghunath Hamta on 3/7/1999 before the officer in charge of Mudulipada police station, bracket relevant to PW15, in short is that the deceased was his younger brother and on 36/1999 After finishing the cultivation work at about 10 a.m., he had been to Kumbharput market to purchase groceries. He didn't return home. On the next day, that is on 1st of July 1999, PW4 Prafullo Ayar came to PW3 in the evening hours and told him as to why he is looking for the deceased who had already been murdered by the appellants last night at about 9:30 p.m. He PW4 further informed PW3 that he was forcibly called by the two appellants, and they all the three buried the dead body at Tolo Kupuli. Tolo Kupuli. Tolo. After hearing such after getting such message from PW3, PW3 along with ward member, the ward member Samsundar Hantal,
PW5,
bracket PW5, Chandal Mudali PW7, Dhananjaya Sisa PW6, and others called for a panchayat in the village, and PW4 informed the punch members about the entire occurrence, and both the appellants who were present in the village panchayat confessed their guilt and told that since the deceased slapped them, they killed him by Tangia. And out of fear, they took PW4 with them, and all the three buried the dead body of the deceased at Tolakupuli. PW4 led others to the place where the dead body was buried. Stop. On the basis of such a first information report, Mudulipada PS case number 30 dated 3/7/1999 was registered under section 302(201) by 34 of the Indian Penal Code against both the appellants by PW15 and he himself took up investigation of the case. Stop. Stop. During course of investigation, PW15 examined the informant PW3 and other witnesses, visited the spot, that is the burial place, and the dead body was disinterred from the ground, and inquest was held over the dead body in presence of the witnesses. An inquest report Exhibit 4 was prepared. Thereafter, the dead body was sent to the hospital. ये जो PM डॉक्टर की है PW14 अच्छा Khariput CHC for postmortem examination. Stop. The IO PW15 also seized bloodstain earth and sample earth from the spot and prepared seizure list, Exhibit 8. He also seized the check lungi, bloodstain check lungi, and one fauda. On 6/7/1999 from appellant Samara number 2, IL, appellant number 2 Samara IL, in presence of the witnesses as per seizure list, Exhibit 9. He also seized a piece of wood from the burial place in presence of the witnesses as per seizure list, Exhibit 10. And on 6/7/1999, he also seized the bloodstain tangia and one check lungi stained with blood from appellant number 1 Madhu IL as per seizure list, Exhibit 11. The IO received the PM report and made requisition for collection of nail clippings of the appellants, made a query to the doctor PW14 who conducted postmortem examination over the dead body of the deceased, obtained query report marked as Exhibit 7/2. He forwarded the bloodstain exhibits to for chemical examination through SDGM, London SDGM, Malkangiri, and obtained the C report filed Exhibit 13, and also the ballistic report marked as Exhibit 14. He made a prayer before the London magistrate for recording the 164 CRPC statement of PW4, and accordingly the same was recorded. On completion of investigation on 3/11/1999, he submitted charge sheet under section 302(201) by 34 of the Indian Penal Code against both the appellants. After submission of the charge sheet, the case was committed to the Court of Session, where the London Trial Court framed charges as aforesaid against the appellant, who pleaded not guilty and claimed to be tried, and accordingly, the sessions trial procedure was resorted to establish their guilt. Stop. In order to prove its case, the prosecution examined 15 witnesses. The prosecution also exhibited 15 documents and also took one material object, that is MO1 is the time. The defense plea of the appellants is one of denial, and it is pleaded that false case has been foisted against them. The London trial court, after analyzing the oral as well as documentary evidence on record, came to hold that on perusal of the medical evidence, it was found that there were injuries on the neck of the deceased, which were antemortem in nature, and it is also a case of homicidal death. Stop. The London trial court considered the statements of the witnesses and came to hold that the evidence of PW3 and PW4 proves that PW4 was called by the accused Samra from his house to assist them take the dead body for the purpose of burial, and the London trial court also accepted the evidence of PW6, PW7, PW8, and PW10, and came to hold that from the evidence of the aforesaid four witnesses, it unerringly proved that in their presence in a village meeting called by them, both the appellants came and confessed that it was the appellant Samara Ayal who hacked the deceased to death by means of an axe. And therefore, this is piece of evidence can be utilized as extrajudicial confession. The London trial court, taking into account the evidence of PWs 3, 4, 6, 7, 8, and 10, came to hold that it was the appellants who were the authors of the crime and had killed the deceased by hacking to death by means of a tangia hyphen, that is MO1. The London trial court further held that there is evidence on record to show that both the appellants, in furtherance of their common intention, have murdered the deceased and were disappearing the evidence to screen themselves from the offense. and further held that the discrepancies which are appearing in the evidence of the witnesses are minor in nature, but the totality of the evidence proves that both the appellants came to the place of meeting, confessed before the villagers, and therefore the evidence of the witnesses on this aspect cannot be discarded on the ground of minor discrepancies. Ultimately, the Land and Trial Court came to hold that the appellants not only gave fatal blows to take away the life of the deceased at the spot, but thereafter both of them brought PW4 from his house and took the dead body for the purpose of burial. And their common intention is very much apparent from their conduct, and therefore both the appellants are equally liable, as if one of them inflicted, even if one of them inflicted the blow on the neck of the deceased by bringing his life to an end, and therefore held both the appellants guilty under section 302, 201, Y34 of the Indian Penal Code. When the matter was taken up on 19/8/2025, a report was produced before us from the inspector in charge of Mudalipada police station, which is dated 7/8/2025, which indicated that the appellant number 1, Madhu Ayal, died since 30/3/2017. Since none of the near relatives of the said appellant filed any application seeking leave to continue the appeal within the prescribed period as per the proviso mentioned under sub-rule 2 of section 394 CRPC, which corresponds to 435 of BNSF. The
within prescribed period or till date.
The appeal stood awaited in respect of the appellant number 1. Stop. Therefore, the appeal now survives only for appellant number 2, Samara Iyer. Mr. Devasi Sarangi, Land Counsel, appearing for the said appellant, argued that there is no direct evidence in the case. The case is based on circumstantial evidence, and the circumstances which are appearing on record are not clinching, and they do not form a complete chain so as to unerringly come to the conclusion that it was the appellant was the author of the crime. Land Counsel argued that the so-called extrajudicial confession stated to have been made in the village meeting cannot be accepted, as there are discrepancies between the statements of the witnesses to such confession, and it has been brought on record that the appellant was originally reluctant, but when the villagers insisted, he admitted to have killed the deceased. And in the scenario, it cannot be said that the extrajudicial confession was a voluntary one. The Land and Council further argued that though PW4 stated that the appellant number 2 Samara called him from his house and stated to have killed the deceased by means of an axe, but the said witness has been declared hostile by the prosecution, and in the cross-examination himself has stated that Samara did not come to his house and called him and told him to have killed the deceased. He further argued that the dead body stated to have been disinterred from its burial place, and inquest report exhibit 4 was prepared thereafter. But though the executive magistrate PW13 has stated that PW4 led him, police, and the doctor to the place where from the dead body was disinterred, but the IO PW5 is totally silent that the dead body was disinterred on being laid by PW4.
IO PW15.
PW15. And moreover, there is nothing in the inquest report, Exhibit 4, that the body was disinterred at the instance of PW4. The Land Council argued that in view of that, though the one axe has been seized from the appellant who Madhu Iyer Tangia, Madhu Iyer, but when it was sent for chemical examination, the chemical examination report, which has been marked as Exhibit 3, indicates that the origin of the blood and the group of the blood could not be opined. The Land and Council further argued that the wearing apparels of both the appellants were also seized, and the chemical examination report indicates that no blood was found in the lungi of the appellants. And in that view of the matter, it cannot be said that the circumstances proved by the prosecution are sufficient to hold the appellant guilty. And the Lennon trial court has not assessed the evidence report properly, and therefore it is a fit case where benefit of doubt should be extended in favor of the appellant. The Land Council, Mr. Naik, led an additional government advocate, Mr. Jateshwar Naik, on the other hand, supported the infant judgment and argued that even though there is no direct evidence available on record against the appellants, but since there is evidence of extrajudicial confession not only before PW4 but also before the co-villagers and the and the dead body was dissented from its burial place, and PW4 was aware about such place as he was taken forcibly uh, to that place by both the appellants. Therefore, the Lennon trial court has rightly found the appellant guilty of the offense charge. Adverting to the contention raised by the Lennon counsel for the respective parties, and let us first deal with the prosecution case as to whether the prosecution has successfully established that the deceased died of homicidal death or not. In this context, apart from the evidence of, apart from the inquest report exhibit 4, the evidence of PW14, the doctor who conducted post-mortem examination over the dead body at High Court CSC on 4/7/1999 is very relevant. The doctor noticed one external injury, which is popliteal. He, on internal examination, found that the vessels of the neck were cut, and he opined the cause of death was due to excessive bleeding and hypovolemic shock and AR embolism. We further opined that all the injuries on the deceased were antemortem in nature, and the injury were sufficient to cause death in ordinary course of nature. He proved the post-mortem report as Exhibit 5. It appears from his evidence that the IO produced the Tangia bracketry MO1 before him, seeking for his opinion regarding possibility of the injury sustained by the deceased with such weapon, and the doctor has given the positive opinion as per the opinion report Exhibit 7. The evidence of the doctor has remained unchallenged, and the Lennon counsel for the appellant, Mr. Sarangi, has also not challenged the homicidal death aspect of the deceased. Therefore, on the basis of the inquest report finding, the evidence of the Dr. PW14, as well as the postmortem report finding Exhibit 5, we are of the view that the Lennon trial rightly came to the conclusion that the deceased met with a homicidal death. Stop. There is no dispute that there is no direct evidence in the case, and the case is based on circumstantial evidence. Law is well settled that in order to base a conviction on the basis of the circumstantial evidence, the circumstances proved by the prosecution should be clear, present, trustworthy, and the circumstance should not be explained, cannot be explained under any other hypothesis, and the circumstances taken together must form a chain so complete that it must unerringly point that it was the appellant Enoru were the author of the crime. Keeping in view this principle, which has also been laid down by the Honorable Supreme Court in the case of so 84 Supreme Court, we are now to analyze the evidence on record as to how far the circumstances have been established and how they form a complete chain to uh, to come to the finding that the appellant uh, is the author of the crime. In this respect, the evidence on record uh, indicates that it was that PW3, PW 6, PW 7, and PW 10 are the witnesses to the extrajudicial confession in the village panchayat shop. PW 3 has stated that the panchayat was called in presence of all the villagers, and the appellant Samara was called appellant, but he did not come to attend the meeting. The witness has been declared hostile by the prosecution. PW 6 has stated that a panchayat was held in their village in presence of the villagers. Accused Samara IL came and confessed before the villagers who have had Ghasiram Antal to death by means of an axe. However, in the cross-examination, he has stated that it was appellant Madhu IL who told before the panchayat that appellant Samara killed the deceased before the villagers, and Samara IL had not attended the meeting, had not attended the panchayat. Therefore, the evidence in chief is contradicted by in the witness in the cross examination, in as much as even though in the chief examination he has stated that it was the appellant Samara who came before the panchayat and made the extrajudicial confession. In the cross examination he has stated that Samara had not at all attended the meeting. Rather, it was the appellant Madhu who implicated the appellant Samara to have killed the deceased. PW 7 has stated that a panchayat was held in the village and he was present in the said panchayat, and appellant Madhu IL came and confessed before the panchayat that it was the appellant Samara who committed murder of the deceased by means of an axe. Therefore, if at all this extrajudicial confession is taken into consideration, it appears that it was self-exculpatory in nature. Therefore, in view of the settled position of law, it is difficult to place reliance on such confession. Moreover, so far as the PW10 is concerned, he has stated that a village meeting was held and appellant Samara confessed in the meeting to have killed the deceased Ghasiram. And in the cross-examination, he has stated that the appellant was originally reluctant, but when the villagers insisted for his confession, he admitted to have killed the deceased. In the cross-examination on recall, this witness has stated that he had deposed in court twice, once as a PW6 and second time as PW10, and once in the name of Dhanurjaya Naik, and the second time as Dhanurjaya Sisai. He further stated that he had not seen the appellant Samara appearing before any panchayat and making confession of his guilt. Therefore, the examination in chief that Samara came to the village meeting and confessed before the to have killed the deceased has been given a complete go by in the cross examination. Therefore, the evidence of these four witnesses to the extrajudicial confession, as discussed above, would show that they are contradictory to each other, and the evidence is not consistent, and moreover, it is also appears that the evidence is not consistent as to who confessed before the village panchayat, and whether it was appellant Samara himself or it was appellant Madhu Iyer, and moreover, it appears that the appellant was not at all originally was reluctant, and after the insistence of the villagers, he confessed his guilt. Therefore, in view of such evidence relating to the extrajudicial confession in the village meeting, it is very difficult to place reliance on the same. And we are of the humble view that the London trial court was not justified in placing reliance on the evidence of extrajudicial confession as adduced by the prosecution in the in the village meeting. So far as the extrajudicial confession before PW4 Prafulla Ayal is concerned, he has stated that the appellant Samra called him from his house and told him to have killed the deceased by means of an axe, and called him to the place of murder, to which he refused. In the cross-examination, he has stated that he had not seen the occurrence nor the dead body since he had not come out of the house. And he has stated in the cross-examination further to the questions put by the defense counsel as follows, quote further, "It is not a fact that Samara came and called me from my house and told to have killed the deceased." Stop. Nothing is available on record about the closeness between the appellant Samara with PW4 Prafullo Ayal. Therefore, the question of reposing confidence on PW4 and making an extrajudicial confession uh, is a doubtful feature, and it is also not now from record that by making such confession, what benefit the appellant Samara would have got from PW4. The extrajudicial confession in the nature of in view of the settled position is a very weak piece of evidence, and in the present scenario when the witness has been declared hostile by the prosecution and his version in the chief examination is contrary to the evidence given in the cross examination, and therefore it is very difficult to place implicit reliance on the evidence of this witness and to hold that the extrajudicial confession evidence is trustworthy and above reproach. Stop. The IO no doubt has seized, as for his evidence, one acts from the house of on production by the appellant Madhu IL. But Mr. Sarangi has rightly pointed out that as for the chemical examination report exhibit 3, the tangia was not found from the tangia, the origin of the blood or the groove that could not be ascertained. Similarly, the lungi which were seized from the appellants also found no blood was found on it. Therefore, the seizure of the tangia or the lungi from the appellants are no way helpful to the prosecution to establish the guilt of the appellant. In view of the foregoing discussion, we are of the view that in view of the nature of circumstantial evidence available on record and the doubting features which has been pointed out relating to the extrajudicial confession made either before PW4 or before in the village meeting is a doubtful feature, and therefore the circumstance cannot be said to have formed a complete chain so as to unerringly point towards the guilt of the appellant. And we are of the view that the Lennon trial court has convicted the appellant on the basis of surmise and supposition which have no place in the criminal trial, and the conviction of the appellant is not sustainable in the eye of law. Accordingly, the same is hereby set aside. The appellant is acquitted of the charges under section 302, 201, 34 of the Indian Penal Code. Stop. ये कौन अच्छी दिक्कत है ना धारा जी इन बेल अच्छा since the appellant has been bail to bear bond stands cancelled, activity on stand discharge. Put a note of appreciation in Mr. Garasi's name. Mr.